tēnā tātou, tātou ngā wai te mai nei ki tō tātou nei whakapapa I tēnei atatoni. E mihi kawakira ki tātou. E mai ta ānei, tai ātinana mai, te tai huitangi mai, te tō tātou nei kuhui mai I tēnei wā. Nā te tohu o te tētihi, patu tēnei, te tuku atu rāta au mihinga ki tātou mea o tātou nei mate. Me tētihi ki te mera, ki te marae tēnei wā toni. Kei reira e tako tō tētihi o tātou nei huia, atu mai rā ki tētihi nei. Me pai wāhi anō ki te tuku atu rātu mai ara ki rātou, e moi koutou, e moi. Tātou e tara hui mai nei, tēnei wā toni, aku kai mua. Mai whare nini hiki wai tōtara ki kai pake, no mahara mai whakatau mai rā. Nuri rā, tāwaki ki āke, tō tātou nei kōpoko I tēnei wā, mā takaraki. Tēnā ki ara kai runga ko te aro, tēnei ki ko te aro, tēnei ara ki te aro, tēnei mākwai. Te aro rangi nui e tūnei o papatu nuku e taputo nā, ki ara rā uho rā, tēnei te poho, nā mai te ao. Nā mai te ao te unki o mai rā tōha ki tēnei mauki ora. Kuri hea te pōhiri uri te pōhāngu ki tua kai, te tuki kai, te rara mahura mai te rā. Uru te moa te tōtoro kukuhinga tamari, te kua te kai pōhira mai te haia, tēnei tau I te ohunga tēnei manawa ora. He nomo he whakati ā, ki ruka turu waka mā, kia tīna, tēnā hui e, orina kita.
Kia ora, thank you very much for that karakia. Antoine, I wonder whether you might be able to just respond for the hearings panel. It would be nice to get underway with Kōrero.
Kia ora mai tātou. E rongo atu koutou ki ahau. Ka pai. Waihoi te toi poto kaua I te toi roa, tuku atu te wairua kia rere ki ngā tāngata. Hei arahi a tātou mahi. Mea tātou whai ngā tikanga rātauma, kia mau, kia ita, kia kora I ngaro, kia pupuri, kia whakamaua, kia tīna, haumi e, hui e, taiki e. He apakura he mō tia ki te hunga mate, he mamai aroha ki a rātou te hunga mate, I te nui tonu puta no I te motu, haere ngā mate, haere atura. He mihi kawana ki o koutou, I whakatau I a mātou I runga te kaupapa mo tīnei rā, he mihi kawana ki a koe te rangatira I te mata I tātou hui runga kupu te atua, tia reira kei te mihi, kei te mihi. He mihi kawana ki ngā karangatanga hapu, ngā iwi, ngā marae maha, puta no o te rohi potai o Taranaki, a te kāhui o Taranaki, he mihi kawana, he mihi kawana. Ko tēnei mātou te rōpu e tautoko ana tā mātou tia mana e moki ana e noho ana I tāna tūru. Ora he mihi kawana kia koutou e noho mai rā, o tira e noho e ngā kāinga I runga tahuora, nore e mihi kawana kia tātou katoa. Tēnā koutou, kia ora whānau.
Kia ora. Thank you, Antoine, and it's a lovely way to start a big day like this with the karakia from Taranaki and the response, Antoine. I really appreciate it. It's feel the spirit of the place already, so very good. So, look, I'd like to introduce myself. I'm Stephen Daish. I'm the hearings panel chair. I hail from Napier Ahuriri, and my professional life has brought me to Taranaki a few times for other hearings, so quite a familiar place. My mum's family's from Taranaki as well, so there's me. Antoine, just a quick introduction from you.
Hey, kia ora everybody. Antoine Coffin, Independent Commissioner. Been involved in Māori resource management for about 25 years, residing in Tauranga, and have had some previous experience in Taranaki working on some of the plan changes, including the Wahitapu site significance being incorporated for Ngāti Rahiri into the plan, and also one of the private plan changes at Uakura. Good to see everybody. I'm really disappointed that I wasn't able to join you in person. We had a really awesome week last week, and it's just that's just the nature of things with COVID have changed. So just glad that everybody's safe and sound in their homes or respective places. So just good to see everybody. Kia ora.
Kia ora. David, would you like to introduce yourself?
Good morning, everybody. David McMahon, Independent Hearings Commissioner, based in Wellington, and becoming more and more familiar with issues Taranaki as these proceedings carry on. Just like to echo Antoine's comments. Disappointing that I can't be in person also. Just the circumstances that Antoine outlined have made it difficult for travel for me. But rest assured, I've read everything and looking forward to a very big day. Thank you, everyone.
Kit?
Tēnā koutou katoa, ko Taranaki te maunga, ke te tai o rehua te moana, no tāmaki makaurau aho, ko Kit Littlejohn toko ingoa. Good morning, everyone. Great to see you all there on a small corner of my screen, beaming in from Tāmaki Makaurau. Looking forward to a wonderful day. Tēnā koutou katoa.
Thank you very much. Julie, could we have the health and safety briefing, please?
So, kia ora koutou. So, in terms of health and safety, if the siren goes for a fire, then the exit is through the main entrance that you came in. If there's an earthquake, drop cover hold as best you can, and then we will await direction from the Devon staff. Toilets are through the seated restaurant area and to the right, or straight down the corridor that you came in and to the left. Most importantly, the Wi-Fi password is book direct. In terms of COVID protocols, we ask that you keep your masks on if you're moving around and as you come into and leave the room. But once you're seated or once you're presenting to the commissioners, you're welcome to take your masks off. And just noting that we are recording today's proceedings. Tea and coffee is available at all times outside through the machines in the foyer.
Thank you very much, Julie. So just a few matters to cover. This is day 4 of hearing 5 out of, I think, 23 or 24 we'll be working our way through over the next year or so. The Independent Hearings Panel, we have delegated authority from Napier, second time I've done that, New Plymouth District Council, to hear and make recommendations to them on all of the matters we're hearing on the district plan. We have issued some interim guidance around the key strategic directions chapter, and that was signalled in our hearings procedures. We thought that was important just to set the scene for the plan. Those matters are interim. We made it clear in the minute that went with those that we are interested in still hearing views on the direction that we are thinking about currently, because those matters really have to be reconfirmed back after we've heard all of the evidence and all the matters, and we'll have a look at those again towards the end. We will be issuing our decision in our recommendations to the council in one block at the end of the hearings in the April or May. In terms of our process, even though this is a quasi-judicial process and we have a number of protocols and matters that we need to follow and me as a chair need to follow, you'll hear through the hearing that it is as informal as we can possibly make it. You'll note that sometimes we use first names when we're familiar with witnesses. That no matter, that's just a courtesy thing really from me, and it doesn't sort of imply any sort of bias or anything. It's just that I think it sort of flows a bit easier that way if we know the people. In terms of the Zoom protocol, where we have a Zoom hearing with more people on the Zoom than would normally occur, the way we run things is that when you're not speaking, if you could turn off your both your camera and your sound, because it lets me just focus on the people who are in the present. So the panel, we'll be asking questions, and the people that are actually speaking to us at the time. And that just coordinates things. Kit and I ran a hearings 4 over Zoom when we were initially in lockdown, and that worked really well. So yes, will be it's informal, but we're lots of respect is what I'm looking for in terms of just the way the hearings unfold in terms of the questioning, and we've had a fantastic start to a hearing with a really great bunch of submitters, matters on the table, and just working through those as we go. I would like to acknowledge the work of Sarah Marco in coordinating the iwi submissions. I've had some feedback from the council that Sarah's role in coordinating has been incredibly helpful for the process. I'd just like to acknowledge you, Sarah, and certainly that just shines through in terms of the way the various pieces of evidence have been presented. They're nicely sort of consistent, integrated, different people talking about different aspects in their areas of expertise. So thank you very much. And yeah, just probably reconfirming from me in terms of the expert role of tangata whenua. My position as a commissioner is tangata whenua are experts in their knowledge base in RMA proceedings, just in exactly the same way that a landscape person could be an expert or an ecologist. So that's my way I think about evidence from tangata whenua. So you do have an important role in building this plan into the future. So just want to acknowledge that. We do, as a panel, have a schedule of matters on a register where we've declared work we've done in Taranaki and any potential conflicts of interests. And with this small community we are in New Zealand, there are a range of matters that the hearing panel have been involved in. I've carefully looked at those matters and we've organised our panels to avoid any potential conflicts. But at the start of every hearing, we just need to reconfirm that there's no concerns about 4 panel members sitting on this from any past or potential conflict of interest matter. So I really just put that to the floor and just see if there's any issues to discuss. Seems like we're all clear again, that's good. Now, I do like to just get appearances just so we know who's who. Got a big group here, but I think it is worth just basically going around the room, and then we'll go around the Zoom room and just say a quick hello and where you're from. So Mr. Holsbush, just starting with you, Keith.
Good morning, Mr. Chairman. Good morning, Commissioners. Sure, if I know. Keith Holswick, you all know me. It's wonderful to see so many iwi hapu people turn up here today on a special occasion. I'll be representing my hapu later on this afternoon. Kia ora tātou, Harris,
Thank you.
Tēnā koutou tātou, ko te Pohi Campbell tōku ingoa, and I'm representing te kotahi tango te Aotea o today.
Thank you very much.
Morena, Sarah Mako, te kotahi tango o te Aotea. Kia ora, Maria Hokpaira, te kahu o Taranaki.
Thank you, Mary.
Morning, everybody. I'm a runaway this morning. Greg White.
Thank you, Greg.
Good morning, everyone. My name is Sarah Edwards, and I'm visiting the Independent Council.
Yeah.
Kia ora tātou, ko te kautau mō te apu o Ngāti Pāpu.
Okay.
Nā koutou, ko Sarah James, te apu o Gibson, tōku uru ki te kaulaka hau o te kaupapa o
Kia ora, Sarah.
Kia ora tātou, Richard Bain, landscape architect on behalf of the Council.
Richard.
Tēnā toto, Mutu Ritai, on behalf of Ngāti Mutu.
Yeah.
Kia ora koutou, Marlene Benson, on behalf of Te Ngāti Mutu.
Kia ora, Marlene.
Kia ora tātou, Josh Richardson from Plymouth District Council.
Hey, Josh.
Kia ora, Grace Martha from Taranaki Regional Council, just here on a watching brief.
Welcome, Grace.
Morning, koutou, Adelaide Campbell, Taranaki Regional Council.
You're Ella.
Kia ora tātou. Casey Bellamy tōku ingoa, koutai o te whai Taranaki Regional.
Thank you, Casey.
Morena, Larry, we have Ramana Ngāti
Thank you.
Tēnā koutou, Sean Zilches, Tamaki Maunga Project. Tēnā tātou katoa, ko tāne manu tōku ingoa, ko ai te mema o te apu o ngā mahanga rawa ko Ngāti Tai.
You're
Tēnā koutou, Joe Ritchie, District Planning Team, New District Council.
Joe.
Kia ora, Renee Davies, Criminal Designer with Plymouth District Council. Kia ora, Sharon Stead, Ngāti Tai Hāpū.
Thank you, Sharon.
Kia ora, Helen Johnson, I'm a planner and I'm a student assistant.
Thank you, Helen.
Kia ora, hori o ka wano, kāwi o Taranaki.
Welcome.
Nā tātou Dion Tūru, Kotahi Tangata.
You're Dylan.
Tēnā anō te pare, ko Araru Waitōku ingoa, here representing Pukerangi Ora Hapū and Marakuri Reserve Trust.
Kia ora.
Kia ora, Julie Healy from Ngāti Defence Industry.
Julie. Okay, Patsy, I can see you there. If you could say hello.
Kia ora koutou, Patsy Bodgen no Manukuri Apu Waitara.
Hey, Rowan.
Tēnā koutou, Rowan Williams, New Plymouth District Council, Relationship Manager.
Kia ora, Maya.
Tēnā koe, tēnā utira, tēnā tātou katoa, Maia Wikaira, Māngai, Legal Representative for the Tangata Whenua Submitters.
Thank you. Right. See DM there. That's David's DM, of course he is. Jamie Tuta, sorry David.
Tēnā tātou, he uri au o Taranaki Maunga, ko Jamie Tutange ai.
Welcome. Sarah Herbert, you're online today.
Kia ora koutou. I'm sorry I can't be here in person. I had a bit of a medical emergency late last week. But anyway, I'm the ecologist for Wildland Consultants Limited and just helping out MPDC.
Thank you for joining us, Sarah, and hope everything's okay now. Thank you. Hilary.
Good morning, everyone. My name's Hilary Walker. I work for Federated Farmers and reluctantly unable to be there this week given COVID lockdowns, but you're all the best for today.
Thank you, Hilary. Stefan Kiss. Stefan, are you there? And there's Fran as well, just trying to connect. So look, I think we'll carry on. So thank you for those appearances. Are there any questions before we start the proceedings?
I do.
Yes.
So who are our fellow colleagues?
Oh, sorry, of course. Oh. All right, the most important ones. That's right. Apologies for that. Right.
Kia ora koutou, ko Rā Macbeth, taku ingoa. I'm the reporting officer on the Ecosystems and Indigenous Biodiversity chapter.
Kia ora koutou, ko Denise Young tōku ingoa. I'm the reporting officer on Waterbodies, natural features and landscapes, and public access.
Denise.
Kia ora koutou, Julie Straka, taku ingoa, hearing administrator. Today's hack. Good morning, Christine Brummel. I'm the administrator assisting also along with Julie.
Thank you very much, everybody. Well, we do have some legal submissions which we normally start with. So, Maya Wakaira, do you want to kick us off? And this case is really, I understand you're representing all of the iwi submitters. Is that correct?
That's correct, sir, which is why
Yes.
they're referred to as the Tangata Whenua Submitters.
Yes.
I understood, sir, just for purpose of clarification, that there might be one further submitter from last week who was required
Yes.
to present in advance of us. Would you like to have them present first?
The update from Ms. Straker is that we have a Mr. Beard and a Mr. Phillips. Mr. Phillips being caught short on a flight, so he won't be starting first. We'll have to interpose him with, if you're happy with that, at the correct time, probably after morning tea, or we'll insert him somewhere straight after one of the breaks, depending on when they arrive, if that's acceptable. Yes. So, Mara, it's your case and your day, so we'll just hand over to you and you can introduce her. Thank you.
Oh, kia ora,
Before we do, I see
Yes.
Mr. Coffin had something to say.
Yeah, apologies. It's always interesting trying to do this online. If you can see my hand raised. I had a question for Ms. Makaida before she starts. Obviously, you're not able to be with in person, and I just wondered about your availability. Particularly, I've got some questions for a number of the witnesses, but some of them might be helpfully supported by yourself. So I just wanted to get a sense of your availability over the next couple of days.
I'll be available and present, albeit off with my video off where I'm not speaking, but available to appropriately interpose right throughout the course of the tangata whenua presentation.
Thank you.
Thank you, Antoine, and keep putting your hand up. I've got you on my screen now, so the previous
dangerous. I have to behave myself now.
The previous hearings, all we could see was the person speaking, so it was not quite as easy to chair, but this is really good. So yes, thank you, Maya, over to you.
Ka whai. If you'll indulge me, sir, appearances never really lead themselves towards a longer mihi, but I'd like to take the time to acknowledge those in the room and those joining us by Zoom. Nā reira, tuatahi e te pāwhakawairua I heri I te rangi ki te whenua ki te rangi, tēnei ka mihi ki a koe. Tēnei ka mihi hoki ki ngā iwi o Taranaki kua tai mai, I runga I te karanga o tēnei kaupapa whakahirahira, o tērā I runga I te karanga o tōrohe. Ko koutou ngā kaitea ki ngā mara whenua o te rohe nei. Kua tai a tinana, kua tai hoki a runga I tēnei hui ahiko. Kia whakamana haere I tō koutou rangatiratanga I roto I te rohe o Taranaki. Nā reira tēnei ka mihi kia koutou. Ka huri ake kia koutou e ngā kaiwhakawā o tēnei o ngā muhoana. Kia koe te hea mana Daesh, o tira kia koutou katoa o te pai I ngā commissioners katoa. Tēnā tātou, tēnā koutou, tēnā tātou katoa. It is a real pleasure, albeit by Zoom, to be representing the tangata whenua submitters today, and it's a shame that it has to be by Zoom, but I'm appreciative of the technology and not feeling that it's inhibiting my ability to present. If at any time, however, there are some issues as to the ability to hear me, please just let me know. Commissioner, feel free to interrupt, Commissioner Daesh.
Thank you.
And I'll make sure what I'm doing at this stage is joining by phone, albeit I am appearing from my office and therefore have a strong internet connection. But if there are any issues, perhaps I'll switch to computer audio.
Just out of interest, are you beaming in from Otutahi or?
I am beaming in from Otautahi, yes. I'm now based in Otautahi and beaming in from Otautahi.
Okay, great. Thank you.
So thank you also for the opportunity, Commissioners, to provide my submissions in advance, albeit through approved late filing. I appreciate that there may have been limited opportunity to review submissions, but thought I'd just take an indication.
I read your submissions on my phone on the way north from Otutahi last night, so but I have read them through and do have a few questions for you, so that's where I'm at, so thank you. Antoine, have you read through?
Yes, I've read the legal submissions, but I'd be helped by perhaps Ms. Makaida just going through some of the key points again. I just wondered too, Stephen, whether you would like us to ask questions as we go, or should we just because we're online, should we just wait to the end and then ask questions?
Yeah, I think just with the online system, it probably works better just to hold your questions. Thank you. Kath and David, you've read Ms. Wakara's submissions?
Right, yeah, I've read them all and got some notes and some questions, and had a look at a few of the cases as well. Thank you.
Thank you.
Yes, Stephen, likewise, I've read them and I've made notes under each of the 5 sections that Ms. Bakar has submitted on.
Thank you.
Thank you, Commissioner, for further indication. I definitely don't intend to read all of my submissions, but may take you to some key passages, and in that regard, where I draw you to particular points, I'll indicate the paragraph numbers as we go. I will start at point 1, just acknowledging who I'm representing today. So my legal submissions are presented on behalf of Te Kotahitanga o Te Awhiawa Trust, Te Kāhui o Taranaki Iwi Trust, Te Runanga o Ngā Te Mutuna, and Te Kāhui Maru Trust, and I'll collectively refer to them as the tangata whenua submitters today. Each of these entities are the post-settlement governance entities for Ngā Iwi o Taranaki, as they are reflected in terms of the specific iwi representation, and these high-level submitters, of course, are supported by a number of presentations from hapu who affiliate to these PSGs and the iwi that they represent, and those people have whakapapa relationships. I've listed the various persons that shall be presenting at paragraph 3. It's important to acknowledge the context to and tangata whenua expectations of the plan, and so I take you to paragraph 4 of my submission. Their very active interest in participating in the new Plymouth District Plan Review and supporting the protection of the whenua and natural resources within the rohe of Taranaki has this very significant context, and that is that the iwi and hapu of Taranaki have been subject to significant land disposition historically, through Crown actions which include raupatu, considered the most egregious of acts of land disposition in Te Tiriti o Waitangi history. So, few iwi in Aotearoa have been subject to raupatu, and while that is a positive thing in our history, it does mean that it's a particular point of significance in terms of the position of Taranaki iwi. Raupatu accounts for the collective loss by the tangata whenua submitters of 1.2 million acres of land within the Taranaki region. And the evidence of Ms. Hoko-Pouda identifies that Taranaki iwi have been unable to effectively exercise mana and kaitiakitanga over an environment that they no longer own or have or control. And unfortunately, this position is common to the experience of all tangata whenua submitters. Notwithstanding that history, the tangata whenua submitters have been working to restore those relationships, and that includes the Tiriti o Waitangi settlements, advocacy in relation to higher order planning documents and restorative environmental projects. And you've read in the evidence and you'll hear in the presentations today about that the work that they have done, particularly in respect of the restorative work. That evidence will come through strongly in relation to the hapu submitters, and I look forward to hearing about their efforts. So in that context, in terms of treaty settlements in particular, they were supposed to, as the Waitangi Tribunal has acknowledged, provide, or the RMA was supposed to, I should say, deliver on Māori expectations of resource management outcomes, and it hasn't. So that is why the treaty settlement arrangements that are spoken to today are of particular significance. But it is also why what has been achieved lately in relation to aspects such as giving effect to Te Mana o Te Wai and other particular Māori concepts that have been given life through national direction, and why they are important as well. They represent the RMA delivering finally on its promise in terms of Māori outcomes. A promise that was arguably made in 1991 when the RMA first came into effect. So the tangata whenua submitters, therefore, today will be making quite clear to you that they have strong expectations of the proposed district plan, and those expectations are that it will deliver better outcomes for Māori, consistent with what they see as the direction of travel represented in higher order documents, consistent with their treaty settlement arrangements, and consistent with this restorative work. And I say that this context is a critical lens to be applied as you, the decision makers, consider the matters before you, and that it should be a context that weighs heavily in the decisions to be made. In my submission, this context is reflected in the RMA mechanisms that, the context can be incorporated and reflected through the RMA mechanisms that are available, which transcend issues as to land ownership, for example, and that's through sections such as the requirement to recognise and provide for, through section 6C, the relationship of Māori with their culture, traditions, ancestral lands, waters, sites, wāhi tapu, and other taonga. And there are a range of other RMA mechanisms that, in my submission, support the panel being able to reflect the expectations of tangata whenua submitters in decisions on the proposed district plan. And in my submission, this context also speaks to the importance of embedding, specifically through local provision, this national direction, particularly in relation to the concept of giving effect to te mana o te wai, as it arises in respect of the PDP. So tangata whenua submitters have strong expectations, and that's all I'll say, because you'll hear more about those in due course. But it's appropriate for me to point out where those expectations stem from, the history associated with them, and the future aspirations that they have, which they'll talk to in more specifics. I turn now to the legal framework, and I've noted at paragraph 11 that I haven't undertaken a comprehensive analysis of the legal issues, and to acknowledge that the panel has heard a broader scale analysis in respect of other matters. In terms of other hearings that have preceded this. What I have sought to do is, acknowledging the key issues that the tangata whenuas have made known to me, I've sought to provide comment on those particular matters. It may be that the panel has further questions, and I may be required to take instruction, but of course where I can elaborate on or respond to those matters on my feet, I shall do so, at least by way of first instance response. So the first issue is the National Policy Statement for Freshwater Management 2020, which I'll call the NPSFM, and acknowledge that it's the NPSFM 2020 where required. I know there is some discussion about the relevance of the NPSFM 2014 as amended in 2017, so I'll be clear where required. By now, it's trite to say that a district plan must give effect to a national policy statement. That's clear from the RMA. And the panel will no doubt be alive to the instruction by the Supreme Court in the King Salmon decision about what that means. It means to implement, it's considered a strong direction, it's considered that it creates a firm obligation on the part of those subject to it. I draw the court's attention to paragraph 79 the panel's attention to paragraph 79 of the EDS decision, and I've highlighted particular emphasis. And of course, this wasn't talking in the context of the New Zealand Coastal Policy Statement, but nonetheless, it was talking about giving effect to the policy statement, so is applicable in my submission in this case. And in that matter, the statement talks about the Minister sets objectives and policies in the National Policy Statement, and relevant authorities are obliged to implement those objectives and policies in their plans, developing methods and rules to give effect to them. To that end, and I draw on this later, the authorities fill in the details in their particular localities, and it is the position of the tangata whenua submissions that those details are still yet to be filled in to to give effect to te mana o te wai. So the first thing that I speak to is I understand that there were some initial issues questioning whether or not there was scope in respect of the implementation of the NPSFM. And I am not 100% sure, but this is why I've noted that there also may be potentially those scope issues have informed where the interim guidance landed in relation to the lesser legal weighting language that is included in that, which is to recognise and provide for. And I know that you've acknowledged, Commissioners, that you'll make comments at the end, but feel free, if you wish, to interpose to provide any clarity there. But I do understand there is a question of scope to provide for the MPS7 2020, and that's a live issue. And the point I'm not quite sure about is whether or not that's had an impact on where commissioners have landed in the interim decision, or whether, notwithstanding the issue is to give effect, you've landed there nonetheless. So I raise the point.
Oops. I'll turn that off. But I've learned that the speaker I use is this one here. Look, I have had to change of mind, and as a chair I'm allowed to do that. I think it would be useful, given the way you've structured your legal submissions, to take questions at the end of each section. So work your way through the MPS FM 2020, and then we'll ask any questions relating to that, and then we'll go to the next topic. Is that okay with you?
Yes, sure.
Okay, sure.
Kapai, well, I just note that uncertainty, which I'm sure will benefit from some discussion at the end of this section. So at paragraph 16, I note that I respectfully disagree with submissions that question scope to apply the MPS FM 2020 to the proposed district plan. And in my submission, it's applicable, and the legal weighting in the interim guidance, therefore, is not consistent with the MPS FM 2020 to the extent that it's proposed in reliance on any questions as to scope. So I've taken, in my submissions, I take you through in some detail the reasons why I consider the MPS FM 2020 can be applied and is relevant, and that the appropriate legal weighting as identified in that document should be applied in this case. At paragraph 17, I'm essentially saying, taking you to the relevant clause within that MPS FM that says every local authority must give effect to this MPS as soon as reasonably practicable. Now, that is a judicially considered term, and it's held to have meant that it's a statutory injunction for expedition in other cases, and that language reflects the desire from the executive in my submission for it to be implemented as promptly as possible. In that regard, it's my submission that this is the first practicable opportunity to promptly implement the MPS FM 2020 in the district plan. And unless, of course, the council makes a decision to do so by way of separate plan change, then we lose the opportunity for a further 10 years. And in my submission, that doesn't meet that expectation of giving effect to the MPS as soon as reasonably practicable. Now, to the extent that there could be any questions arising from Part 4, Clause 4.12 of the MPS about whether or not the language give effect to any associated provisions would have had to be publicly notified when the proposed district plan itself was notified, I submit that this particular section is really about, it's a procedural section. And if it's not interpreted in that way, I say that absurdities could result. So, because you would essentially be limited in your ability to make any changes to that which was notified by the council. And we know, sir, that the expectation of a process like this is that the community participates, that they provide comment, and that ultimate provisions reflect that community participation. And so in my submission, all that is saying is that a process does need to be followed that's consistent with the Schedule 1 process under the RMA, so that the public can participate in discussions about what giving effect to means. That is what, in my submission, what is happening today. And therefore, that particular requirement under Part 4, Clause 4.1, Subclause 2, is being met. It is not an expectation that the give effect to language had to be publicly notified through the PDP. And that I continue with that submission at paragraph 20, and note that there are particular provisions within the MPS FM that actually do say that you can take an alternate process rather than the Schedule 1 process, and therefore that's what the clause is directed toward. It's just making sure that people know there is an expectation that this be discussed in these types of public fora. I turn now to case law in relation to this issue. And I note too that I refer to in quite a large footnote at footnote 16, because I was trying to make the material manageable in terms of digesting and reading it. But I refer in that footnote to the fact that this is a matter that has been considered by another hearing panel, albeit at a regional council level, and that is that was the hearing panel in respect of the proposed Waikato Regional Plan Change 1. Now, they considered each of these two cases and then ultimately made a decision to follow the case that I have listed at paragraph 21, Hawke's Bay and Eastern Fish and Game Council, I'll call it. And it's my submission that that is the appropriate approach in this case as well. So in that particular case, you had a Board of Inquiry decision. It had been appealed to the High Court, and the court directed that the Board of Inquiry reconsider its particular decision. The MPSFM 2014 was issued while the High Court was considering the appeal, and therefore was in effect when would be in effect, everyone acknowledged in the appellate jurisdiction, when the matter was sent back to the Board of Inquiry. And so the question arose, well, when the Board of Inquiry considers this matter, should it consider it with reference to the MPSFM 2011 or the MPSFM 2014? And that court held that the Board of Inquiry should give effect to the operative MPSFM 2014 when undertaking its reconsideration, and it did so acknowledging again, as consistent with my submission, that the executive wanted the MPSFM to be implemented as promptly as possible, and that best reflected the requirements under section 67 3A of the RMA. And so it's my submission, Sir, that that is a more appropriate case to follow in this particular instance than the decision in Horticulture New Zealand and Manawatu Wanganui Regional Council, which I refer to in footnote 16. That was a decision of Justice Koch, and in that case, it was you had essentially a publicly notified plan that had gone through the decision process, and then it wasn't until the matter was before the Environment Court that a new MPS came into effect. So quite a different situation to the one that we have here, to the one that we had in the context of, I was appearing in Plan Change 1, but to the one that was involved in the Plan Change 1 Waikato Regional Plan situation, and to the issue that arose in the Hawke's Bay and Eastern Fish and Game Council decision. An MPSFM hadn't come into effect until the appellate court stage. Now, in that particular context, Justice Koch noted and emphasised, this is in the middle of my footnote 16, the sentence starts in his decision. He emphasised the limited jurisdiction of the Environment Court and the fact that it does not sit in an executive plan making and plan changing role. However, in this case, the panel is making recommendations to the New Plymouth District Council in that role. And that was a point of distinction that was raised by the hearing panel in the Waikato Regional Council case as well. They said, well, we actually in our case, we do sit in that particular role, and that has been a reason why Justice Koch has acknowledged that the point was different in the Horticulture New Zealand case. So it's my submission, Sir, that the express terms of the MPSFM provide guidance that the MPSFM 2020, to the extent that it directs that matters be given effect to, it is within scope to consider those matters now. It is not out of scope simply because it wasn't, the MPSFM 2020 hadn't yet become operative when the matter was publicly notified. My submission is that that is consistent with the approach that has been taken when this particular issue has arisen in case law to date. I note in relation to in relation to this issue about therefore what legal weighting, I say that the legal weighting should be give effect to in relation to Te Mana o Te Wai, and I'm speaking specifically to the interim guidance which refers to recognise and provide for to date, and noted that I wasn't quite sure where that had arisen, noting that the language in the MPSFM 2020 is to consider and recognise, very close but it's still distinct from recognise and provide for. Think two. So my submission is that the legal weighting give effect to is relevant to the New Plymouth District Council's Section 31 RMA functions and obligations. Now, I acknowledge that there are a number of direct express expectations and obligations placed on regional councils to give effect to Te Mana o Te Wai in relation to the MPSFM, but my submission is that that doesn't preclude expectations on district councils. And I make, at paragraph 23, the sub-paragraphs are directed toward the specific clauses within the MPSFM 2020 where I say that that direction applies to district plans. So first, freshwater is required to be managed in a way that gives effect to Te Mana o Te Wai. Therefore, district councils, where they have a management role, must oblige in respect of this direction. The obligation to give effect to Te Mana o Te Wai rests both on district councils and regional councils through the language that is used. Often the language refers to local authorities, which we know under the interpretation and section of the Local Government Act that is a reference to both district or territorial authorities, I should say, and regional authorities, including the New Plymouth District Council. Te Mana o Te Wai must also inform the interpretation of the provisions required by the MPSFM 2020 to be included in district plans as the express language that is used in the particular MPSFM clause. And every local authority, and I've explained that applies to the district council, must actively involve tangata whenua in freshwater management, and as the MPSFM states, including identifying the local approach to giving effect to Te Mana o Te Wai. And then finally, the integrated kiuta-ki-tai approach required by Te Mana o Te Wai calls for, again, the language that's used is local authorities. Two, and I note those expectations in relation to kiuta-ki-tai at Roman numerals 1 through 4. So it's my submission in relation to this section that the MPSFM 2020 therefore requires the Plymouth District Council's proposed district plan to fill in the details on this national direction in the Plymouth District. That concludes that section, and so I'm happy to take questions at this stage.
Thank you, Ms. Bukora. We will pause there and we'll kick off with any questions from you, Commissioner Coffin.
Good morning, Ms. Bukora. Hey, thanks for that. Yeah, just a few questions to start us off. Can you hear me okay?
Yes, I can.
Oh, that's great. This is quite an interesting subject and one that I'm involved in a number of other hearings, and you have situations where a plan's been notified before the MPSFM 2020, and so you're under a previous regime, and then once the MPSFM was adopted, in the absence of any transitional provisions, there is no MPSFM 2011 updated in 2017. So this is an unusual situation where a plan's been prepared under previous MPS, no transitional arrangements, it no longer exists, but you have a new MPSFM, and it's, I suppose I'd like to call it, it's a shift change, particularly in regards to Te Mana o Te Wai and its application. So I just wondered whether you had any particular comments in that regard. The second one is a number of other hearings that I'm dealing with where this situation occurs, the scope of the implementation of or giving effect to the MPSFM 2020 is related to the scope of the submissions, not necessarily just restart the process all over again. So that's the second question. And I've got a third one, but we can start with those two perhaps.
So the first one was, I consider that I've addressed the first question, but happy to comment in my submissions, which is to say that the case law shows that where you have had a particular MPS in place and you've had a notified plan that has essentially, of course, been directed towards that MPS, but then you have a later MPS that becomes operative, and we have this exact situation here, the point that you've made, we don't have transitional provisions as such, instead we have that direction that I've noted, which is to give effect to the MPS as soon as practicably possible, I believe. That in that case, those cases have determined that it's appropriate to apply the MPSFM and, the operative MPSFM as has come into effect or been issued during the course of that hearing, but they have placed limits on that, and those limits have been where you have, for example, an appeal, where you don't have a council that sits in the role of plan decision maker, essentially, and therefore you sitting in your delegated role, where you can make decisions about which is appropriate. And so in my submission, that limit is appropriate. When you get to an appeal phase, it can become very difficult, essentially, albeit in the Environment Court you have de novo hearings, you still have a lot of the first instance material has been prepared on a particular basis, and at that point it becomes very difficult, I believe, to return to those matters and interrogate them with a different lens. So I consider that this issue has been addressed in case law, and that limit was placed on the matter in relation to the decision of Justice Koch in the Environment Court, but in the Plan Change 1 hearing, acknowledging that you're not bound by that, but in that hearing, and in particular also in the context of the Hawke's Bay decision in relation to the Tukituki Board of Inquiry, those two decisions decided that it was appropriate to give effect to the MPSFM, and they decided based on the interpretation of the MPSFM language as it stood, and that language is similar in this particular instance. They're talking about giving effect to it as soon as practically possible. So it's my view that actually that matter is appropriate. It's appropriate guidance for what should be done here. In that regard too, I just note that in relation to the Waikato Regional Plan, it could have been relatively straightforward for the hearing panel in that case to say, well, we have Te Whai Mana and all of the MPSs, well, Te Whai Mana prevails over all of those MPSs, and so to the extent that we're concerned about which MPS, we needn't concern ourselves with it, but they did make a specific finding in that regard, drawing on those two decisions that were applicable in different circumstances. And so I think that's useful guidance about, notwithstanding having a higher order document, still finding value in acknowledging which MPS. Now, as to your second point, it's my view in submission that this is not an issue of scope as it relates to submissions, because it's an issue of the legal framework that should be applied in respect of submissions. So submissions will relate to legal weighting, of course, because people have a certain preference for legal weighting. But the submission point is more about, is the issue on the plan and has it been fairly and reasonably raised in relation to the resource management issues at hand? Not so much is which MPS, because the MPS that applies becomes part of the planning and legal framework, because the planning framework is what are the directions in relation to implementation of the MPS, but the give effect to language, that is a legal weighting issue, and therefore it's actually, in my submission, it's a legal framework question. It's not precluded by the scope of submissions. Otherwise we would reach really absurd outcomes where, say, some submitter had happened to say give effect to because they had a preference, and tangata whenua submitters would likely be in that camp, even though it wasn't the legal language that was used. They simply wrote give effect to in their legal stuff, in their original submission, and then we later had an MPS that happened to use that language. Then we'd have scope in that case, but not in other cases. So my submission is that would create really perverse outcomes where you'd have scope to consider certain things just because some submitter had happened to, perhaps accidentally or perhaps because they had their own personal preference, have included it in a submission, whereas actually a better planning outcome arises from being able to, in appropriate cases, and I say this as one, draw on the planning documents that become operative during the course of your considerations in this very early stage of the plan decision making.
Well, thanks for that. I'm sure Commissioner Littlejohn will also have some questions in that regard for you. Just my last questions just regards the MPSFM and those requirements which you've helpfully listed for us. If I was to look at those and say there are some that are quite broad, and saying using the language of give effect, you must provide for this, there must be engagement. Those seem like starts of a process, or they're process-driven policies, rather than necessarily every district plan must have this, this, and this in it, like being very specific and directive. And I suppose in my mind, that's the thing I'm having a little bit of. It's a challenge to see where we've got tangata whenua submissions and evidence being quite specific about some of the things they would like. We have an MPSFM 2020, but the language being used in particular to districts is a little bit more broad and less directive and specific. And I'm also thinking at the same time with a hierarchy of documents, we have our MPSFM is in place. Regional policy statement and regional plans will be notified by December 2024, and the district plans will then not only give effect to the MPSF, but also won't be inconsistent and recognise those changes that have been made in those higher documents. And we're not quite in that particular rollout of the plans. And I just wondered if you had any helpful guidance to us when we're considering some of the evidence today and possibly tomorrow around some of the specific things being requested by tangata whenua representatives, how they fit within the MPSFM where it's being less directive. Like it'd be easy to say, you must have SNAs in the district plan and meet these criteria. That's very specific, but that language doesn't exist in the MPS, and it's very much focused on freshwater, and some of the subjects we're dealing with include freshwater, but they're not specific to freshwater. So any helpful comments in that regard would be great.
I think it's important to acknowledge that I don't consider that give effect to as broad language. I do consider that is strong directive language. I consider that the question then becomes, well, how do we give effect to at the local level? And that, in my submission, there's always been an intention in terms of national direction documents that where we can, where it's appropriate, that there are specific provisions that that councils are essentially directed to provide for, but also particularly around Te Manawa Te Wai, that discussion is a discussion and the provisions that fill out the direction, drawing on that language from the EDS and King Salmon case, that those provisions happen at this level. And again, I emphasise that I don't consider that it's too late to be having that kōrero now. I consider that bringing the types of provisions to the table that tangata whenua are proposing is entirely appropriate. They could have brought those absent a direction to give effect to Te Manawa Te Wai, but the direction to give effect to Te Manawa Te Wai now becomes part of the directive context in terms of those matters that are relevant to decision makers. I just take 1 minute to just quickly look at the direction. To the extent, sir, that it's my paragraph D, but it's part 3, clause 3.11a. You've noted every local authority must actively involve tangata whenua. That is including identifying the local approach to giving effect to Te Manawa Te Wai. That you consider that could reasonably, and I agree, be interpreted as, well, that's a process-based kōrero. At times, well, I guess the issue is that the MPSFM ends up being provided for at different points in time across the various districts and regions. And so really the kōrero has been commenced, albeit acknowledging that tangata whenua submitters would have been setting their expectations quite clearly for plans for a long time now. It's just they now have this direction. But to the extent that this direction makes decision makers have to consider with more strength the points that they make, then that kōrero is in part commenced, yes, by their submission. And that is, in my view, that's the reason why the matter, it's really, in my submission, we now have a stronger language. I think that proves the earlier points, is that the submission hasn't changed. What they expect of the plan hasn't changed, but the directions on you have. And what give effect to means you do have, the panel does have, in terms of the matters that you consider, some leeway to acknowledge what's right for this district. And actually, in my view, that's appropriate. And that's why, to the extent that the national direction isn't as detailed as might assist, that's because it's important that those locally and regionally specific issues and ways of providing for Te Mana o Te Wai are provided through this plan review process.
Thank you for that. Just a supplementary question. You've mentioned in your legal submissions around that potentially the council could look at a plan change. It could look at reviewing its. And this is this is prefaced. This was a situation that you didn't prefer was wait for a review in 10 years' time. I just wondered if you had a view in regards to the practice of plan making, because we're not necessarily making the plan, we're making recommendations on aspects of the notified plan, and whether you had a preference for a plan change that was able to give effect to the NPSFM and a number of other documents at a particular point in time before a 10-year review, or actually you think that there's sufficient scope within the submissions and enough meat on the bone to actually to provide for the district plan giving effect to the NPSFM?
My strong submission would be that it's appropriate, there's enough meat on the bone, and it's appropriate to give effect to the NPSFM through this plan review. Plan reviews are far more desirable, particularly considering the direction around an integrated Kiutaki Tai approach. My experience in relation to the Waikato Regional Plan Change 1 issue was essentially that you're trying to give effect to Te Ture Whaimana, but the matter, you ended up really precluding scope at the very beginning, notwithstanding Te Ture Whaimana is supposed to permeate all, because it would have been too big otherwise, and therefore we looked only at 4 contaminants, despite the fact the number of submitters were of the view that actually that wasn't sufficient to give effect to Te Ture Whaimana. And so I consider that if you tried to tackle this by way of plan change, you'd have a similar result, which would be that you'd have to find a way to essentially limit the matters, and then in doing so, not be able to consider how the issues interrelate, and you'd end up unpicking the pan in any event in a new plan change, because of the fact that the Te Mana o Te Wai provisions, they're relevant to the subdivision chapter, they're relevant to the solar now chapter, subdivision with reference to the setbacks, of course, and a range of other chapters. So you end up unpicking the plan, and in my view too, you end up essentially seeking to produce a plan at this stage that you know is subpar and will need a revisiting, when in fact it's my view that there's ample opportunity through this process to ensure that those matters are covered now.
Thank you for that. That's all I had just for this section. Thanks, Stephen.
Tēnā koe, Commissioner Coughlin.
Thank you.
Commissioner Littlejohn.
Kia ora. Thank you for that. Firstly, very appreciative of your legal submissions on this topic in particular, because it is it's a very topical issue in resource management at the moment. And I think just to respond to one of the points you made about the interim guidance that we issued, I think it's fair to acknowledge that we took the view that the submissions provided scope to make reference to the concept of Te Mana o Te Wai, and that it was appropriate in those circumstances to rely on that scope to incorporate that concept within guidance, albeit within the frame of the language that it was used within submissions, which is the recognised guidance. I think, again, fair to acknowledge transparently that we did have reservations about the ability to take into account a national policy statement that had introduced itself into the world during the process, and we didn't have a lot of significant submissions on that. So again, very grateful for your submissions, because they do cause pause for thought there. I guess I'll step back from that, because I want to get to that discussion, because there's a couple of other preliminary points that I just want to have a chat to you about, lawyer to lawyer. The direction give effect to, as you've phrased it, is around how local authorities must give effect to this provision. Now, and you've acknowledged as well that local authorities include both territorial authorities and regional authorities. So do you accept the position that that direction to local authorities cannot extend a territorial authority's functions and powers in the RMA, so that it would give a territorial authority a policy or rule-making power that Section 30 or 31 doesn't, on the face of it, give it? I mean, do you have a submission you'd like to make about that?
Yes, I consider that under Section 31 there is clear direction to have particular provisions that relate to the management of fresh water from the perspective of a district council, notwithstanding the fact that in the main, the roles in respect of freshwater management will sit primarily with the regional council, and therefore to the extent that a district council has within it a management function in respect of freshwater, that at that point the reference to local authorities is incorporated into those existing functions. I don't consider that it extends those expectations and functions.
Okay, well that certainly was my preliminary view, because otherwise you'd have a delegated instrument extending the powers of the statutory instruments.
The enabling legislation.
Yeah. Okay,
which
so
they
that's
wouldn't
good.
be able to do.
Yeah, and I agree that the role that territorial authorities have with respect to freshwater is potentially not as limited as they may have historically conceived. And it's something that we'll be debating amongst ourselves as to whether it goes so far as to regulate land use activity, where that activity itself may have an impact on water quality, as opposed to the other things that territorial authorities are traditionally seen to regulate with respect to water. So that's something that again is quite topical as well.
May I just make a comment in relation to that? This perhaps is the obvious point, and maybe the debate and dialogue that you intend to engage in relates to that, is where the issue is perhaps more murky. But I do consider that where the tangata whenua submitters had made particular points in relation to what they'd like to see, the example of subdivision setbacks is a good one in terms of integration with respect to impact on water quality. But it's perhaps the more obvious one, and perhaps you're looking at things that are a little more, a little less certain. I'm not sure.
Well, I think, I mean, that's a good point. I think it's less about outcome, but more about primary purpose. I mean, it's like the debate around the relationship between the RMA and the fisheries legislation. Just because a setback may have an indirect benefit in terms of water quality doesn't necessarily mean it's not appropriate, because a setback also has other functions that are within the powers of the territorial authority. So it just happens to be beneficial that a particular land use planning technique also has water quality benefits. So I mean, I wouldn't rule out a setback just because an aspect of it might have a water quality benefit, because it might be there for a completely different purpose. So that's good. That's another one we agree on. That's good. The case law around application of I guess the reaction of a quasi judicial body in the middle of a process to a new document that comes along is quite an interesting one, and I think the starting point from me has got to be some form of legislative proposition which extends what section or clause 10 of the first schedule gives us in terms of our role as commissioners here. I mean, we are in a first schedule process. Clause 10 effectively confines what our role is, and that is to consider the provisions and the submissions and further submissions and make decisions and recommendations on them. And your argument that after the submission period, a document comes to light that has clear statutory imperative that no submitter referred to doesn't matter. It's simply because it has that imperative of statutory making, we can somehow give ourselves power under clause 10 to make a recommendation on provisions, even though those provisions weren't referred to in submissions. I mean, what's your answer to that? I mean, where do we find the authority to do that?
So it's perhaps the conversation I was having with Commissioner Coffin. My submission is that it comes within your jurisdiction because you're directed in relation to the relevant legal framework that now applies. So it's not a question as to what are the submissions. The submissions have covered the issue. They've talked about Te Mana o Te Wai. It was applicable in the context of the 2017 version of the NPS.
Mm-hmm.
They've talked about those particular issues. All they're now saying is in relation to the submissions that we've all already made, there now sits a different, within the broader legal framework, there now sits a different direction. And so we continue to advance our submissions. Perhaps if you consider the broader community of submitters, some will continue to advance these submissions for, others will advance their submissions again. Mm-hmm. But you now have a different statutory direction arising from the expectations of the enabling legislation with respect to national policy statements.
Well, that's a, can I just interrupt you on that? Can I just interrupt you on that point? I mean, that is an interesting one. I had this argument in front of Judge Smith a few months back concerning the MPS-FM and the NES. And again, that was a submission where the new policy statement and the NES regulations around freshwater came into existence in the middle of a regional plan process. And although His Honour didn't actually comment on it in the decision he issued, but it did very much light upon this point that there are, I mean, we've got two duties is what you're saying. One is we've got a duty under clause 10 to get amongst all the submissions and see what they ask for and then make recommendations on it. But we have a broader role as a planning authority to some extent to constantly keep an eye on those sections way up the ladder in the Act, section 67 and that. And regardless of what a submission says, we still have overriding obligations to implement those provisions as they come to light throughout the course of the process. Is that essentially what you're submitting?
So my submission is that the two duties that you're discussing are entirely reconciled, because you have a duty to respond to the submission and you have a duty to respond to the legal weighting of the language in the relevant document. And so the submissions are asking for a certain thing. And now you're in a position where, in relation to that particular request, you have some stronger legal language, and so you have to consider the request in the context of that stronger language.
So you're saying they are linked?
I'm saying that there's no issue as to scope in relation to the submission.
Well, none of the submissions, though, sought that the plan give effect to the MPS-FM 2020 because it didn't exist when the plan was notified.
But even if no submission at all had used the language of give effect to it had said you must give effect to a national policy statement, you'd still be required to do that.
Okay, so that's the point I was getting at. Yeah, they're two separate and distinct duties as well.
Yeah, they're separate and distinct duties, but they're not irreconcilable, because the submission is saying, for example, if we take the tangata whenua submission that they'd like to see setbacks across essentially all water bodies rather than just scheduled water bodies. They made that submission in the context of the MPS-FM 2014 amended 2017.
Yep.
Now the MPS-FM 2020 applies. The submission point remains, opposition to it remains to the extent that there is opposition, And the question though is, well, what do we as decision makers do in respect of that submission point? There's no issue as to scope, but it's because we now have a different direction arising from this NPS. So that's the only new issue. We now just have a separate legal framework.
So if we follow your argument through, then if in 2 months' time the government gazettes the NPS on Indigenous biodiversity, do we have to go back and reopen the hearing and reconsider all of the submissions that made references to Indigenous biodiversity in the draft statement? I mean, presumably we must. If the duties are ever present and we need to make sure our recommendations on the date we give them take into account all of the documents that are live at that point, then we're in a process of forever having to go back and revisit stuff as the government finally catches up with some useful direction on stuff.
Well, I would also say, sir, that in the government, that if the and so my first response is yes, and I'll explain that shortly. But I would say that the reverse is also true. If the district plan doesn't reflect what the government proposes now, then they're catching up in 10 years' time, or they're catching up through a private plan change later down the point.
They could do a variation.
Down the track.
But they could have done a variation.
Yeah, so that's what I say, through later down the track, yes. And
well, they could have done it now. They could have done it last week. They could have notified a variation last week if they wanted to.
Yes, but my submissions, they don't need to, because it's not, for example, it's not a variation where you're saying we're including a new area, we've missed out this particular issue in respect of a catchment and it was relevant and we haven't notified everyone. It's simply a new part of a legal framework in relation to matters that are clearly addressed within submissions. And in relation to the point that you make about if the government is to provide for an NPS in 2 months' time, I would say that yes, as a result of Justice Kosher's decision and the High Court decision in relation to the Board of Inquiry, Tuki, that yes, you would need to revisit the NPS unless you decided that really, in my submission, Justice Kosher's decision creates the limit, and it starts at if we get to a point where appeals have been lodged, and at that point a new NPS comes into operative effect, then that's too late. We consider. So you might say.
So you're saying it's the lodgement of the appeal which closes the gate.
That's my in my submission. That's what we can take in terms of the ratio arising from Justice Kosher's decision.
Well, I mean, I've got both of those decisions up because I went and had a look at them last night, and Kosher's decision is earlier in time. You then have Justice Collins' decision where he refers to horticulture New Zealand, but then doesn't really address the reasoning in it, as far as I can tell. Now that's an impolite way of a lawyer saying he's critical of a High Court judge's reasoning, but there isn't any reasoning there. He goes from acknowledging Justice Kosher's decision to just taking a different view. And look, I don't need to get into a debate with you about them today because I'm going to go back and read them carefully again to see if the circumstances create different ratios in those instances. One more recent decision that you may want to look at and provide some supplementary submissions on is a decision of alternate Judge Newhook's. The reference is 2021 NZENVC 082, and that concerns a case where a private plan change was on appeal to the Environment Court and the new NPS UD had come into existence, and there was an argument as to whether or not that had provisions in it that needed to be taken into account in the plan change because one predated the other. And ultimately, His Honour came to the view that the provisions of the UD, where they required other processes to occur to the planning framework, were things that had to be done separately, and they ought not to influence the plan making role that was before the court in an appellate function. But look, it's a slightly different creature because the NPSUD is crafted in a very different way to the NPSFM. So I'd be interested if you have a chance to have a look at it. I'd be more than happy to receive some brief supplementary submissions on it.
Certainly, sir. I can quickly note that based on your summary, I would say that it falls into the same category as that of Justice Kosh's decision in relation to horticulture.
Possibly.
And noting that emphasis around the limited jurisdiction of the Environment Court and the fact that it does not sit in an executive plan making and plan changing role. That was Justice Kosh placed emphasis on that, and then noting that the council in this case, and through your delegated function, the panel does sit in that role. So I'm happy to, of course, review the case and provide supplementary submissions, but just to give you a sense of what I'm likely to provide, I would say that those two cases can be distinguished on the basis that they came into operative effect following the appeals being lodged.
All right. Well, I mean, I'm obviously very interested in that because it is a particularly critical point of law here. Either we have a duty that effectively follows what Parliament does mid-process, or we have a duty that starts when the plan is notified and the RMA confines us to it. And it is quite a critical one. So I'd be interested in any further thoughts you have on that. The one last bit I wanted just to talk to you about is to understand a little bit better your response to the argument, and it's your clause 19 of your submissions. Because my note in the margin when I read your submissions, where the NPSFM says that local authorities must publicly notify any changes to their district plans that are necessary to give effect to this NPS, my note was that's a fairly solid barrier to the argument that we now have to do it in the middle of this process, because obviously it hasn't been publicly notified. So I just wanted to understand the way you say that doesn't prevent the taking into account or the giving effect to this document, which has come into existence subsequently and has not been publicly notified.
Yes, so I say, sir, that is about ensuring it notes I note the qualifying words at paragraph 20 of the clause that say as required under the Act, and say that this is about ensuring that any provisions that are discussed in relation to giving effect to the NPSFM 2020 are done through a Schedule 1 process rather than through some of the processes under the NPSFM that are more limited, because there are processes, and I perhaps can draw your attention. So there's a particular clause in the NPS that cross-refers. Sorry, sir, if you give me 1 minute. But in any event, while I'm looking for it, the point to be made there is that there are certain parts of the NPS that can be given effect to absent a Schedule 1 process. And so my submission is that the clause 4.1 subsection 2 is about ensuring that a Schedule 1 process must be proposed in relation to this particular issue, rather than it to be given effect to in any other way.
But that doesn't
So
mean
it's not the public notification.
Oh, okay. So where it says it must be publicly notified, we can ignore those. Well, we can effectively ignore those words, and that the fact that it's turned up in the middle of a Schedule 1 process means that it's all good.
I'm saying that the fact that the issues are covered within this process, those matters were notified, and this is the process that ensures that the give effect to discussion is taking place. So it's not an ignoring. I say that as required under the Act, is showing that this is actually about a Schedule 1 process rather than other more limited processes and that are provided for under the NPS. For example, minor corrections and other types of matters. Those aren't the only matters where you can have a far more limited process.
But this is not a case where, for example, where parties have had an opportunity to contest what the giving effect to outcome looks like in this plan, though, is it? Because it didn't exist when parties were asked to make submissions on the provisions of this plan.
But I say that that's what this hearing process now is about. It's about the opportunity to make those particular submissions in relation to now the application of the legal weighting, but the issues themselves, the key provisions that each of the parties asked for are provided for in the original submissions.
So to that extent, wouldn't we be on safer ground just to address all of this on the merits? And if your client's submissions are sufficiently persuasive to make the changes they request without having to get into a red light, green light sort of scenario in terms of whether we have to or not?
Well, part of it, my submission is that part of you would address it on the merits in any event, but then part of the context is you now have this new legal frame.
Ngā mihi, thank you.
Tēnā koe, Commissioner Littlejohn.
Commissioner McMahon.
Yes, thank you, Sir. Conscious of time, I've been following the responses with interest and crossing a lot off my notes here. I don't want to prolong this discussion unnecessarily, so perhaps I could just say three things. Well, I think there are three issues that are of interest to me in the panel. The first is in terms of giving effect to the yes, first is who, second is how, and the third is when. And on the who question, I think, Ms. Waikaira, it's clear to me, and I think clear to you, that both regional councils and district councils have a responsibility here. So I think we can tick that off, albeit I think you do acknowledge that there's probably a primary responsibility for regional councils. I think the NPS notes that. As to the how question, well, obviously that raises the issue of scope and functions. And I must admit, when I first read your legal submissions, I thought you were advocating for an outcome where relief not specified in the submissions of tangata whenua were could be on the table in an unfettered manner, and I don't think you're doing that. Otherwise, that would be the other end of the perverse spectrum outcome that you referred to earlier. I think what you're saying is that, well, what I'm hearing you say is the relief specified in the submissions can now have the benefit of being considered under the legal framework of the NPS. And so that goes to the merits analysis. Yes, it's not saying, we actually, it didn't take the opportunity to specify this additional relief, and now it's now on the table by virtue of the NPS FM. I don't think that's what you're saying.
No, sir, because I would agree that that would be out of scope.
Yes,
that's where the submissions issues come into play, and I think your comment has been useful because perhaps that has been the discussion that's been had with other submitters, where scope has been far more stark, and those issues would be quite clearly on the table. So, no, I agree with you, sir.
Okay, and the other second component of the how question is the functions, and clearly your answers to Commissioner Littlejohn about having relate to the functions under section 31 of the district council. We can't extend those by virtue of the NPS, but there may well be ways in which we can complement those through land use controls and policies on land use controls. One of the examples that springs to mind, and it's a live issue for the officers, is the role of Schedule 9, which is the scheduled or water bodies, and whether that's about what the purpose of that schedule is. That's a question that the panel was asked, the officers come back and report on. It's obviously, well, we've read it as, most submitters have read it as specifying setbacks as opposed to implementing standards for water quality, so which would be a regional function, obviously. So that's the live issue. The third question about when, that's the one that interests me the most, and we've been told that the government have directed regional councils to produce MPS compliant RPSs and regional plans by the end of 2024. In the normal sense of events, the district plan would need to give effect to those RPS and RPs had they been produced in advance of the plan being notified. That's not the case. So what I'm interested in understanding from you is, to what extent should this council be trying to second guess the outcome of that process, or as opposed to sort of waiting and seeing whether there are any gaps, and it may be that this panel can identify gaps and perhaps recommend variations. That's one way of doing it. The second way is that the council wait and see what comes out of the RPS and regional plan process, and then decide what changes are necessary to their own plan to give effect to those, would then be the higher statutory documents, plan, and then promulgate a variation or a plan change to reconcile any differences. I acknowledge that would be a longer process, but do you think it would be a reasonable process in the circumstances?
I think that the process may be necessary in any event, because you'll have an RPS that will be publicly notified in 2024. They'll move through that relevant process, and then particular provisions will result. But my submission is that the key point that we've made in terms of the who is the territorial authority, so the district council and the regional council do have separate functions, and the obligations attached to those separate functions. And so it's not a matter on the part of the district council of waiting for the regional council to tell them what to do. It's that they have their own separate obligations. They have live issues that are present in this plan, and they have a higher order document that sits above the regional plan and the regional council's responsibilities that gives them direction about what must be done. So in my submission, sir, they shouldn't wait to be told by the regional council, because that would be, in my mind, them not essentially obliging in respect of their own distinct obligations.
Okay, so the situation might arise therefore that by this time next year, or perhaps earlier, when we're delivering our recommended decisions for council consideration, we might be in a position to identify some gaps between what this plan delivers and what the MPS expected, but the submissions lodged to the district plan don't provide scope to allow us to deliver a recommendation on that. So that sort of gap analysis might be part of what we could recommend back to the council. Is that what you're suggesting?
I think so, that would be an appropriate approach, that where submissions provide scope to address this higher order direction and the merits, your merits decision is alive to that those decisions are made now. Yes. But of course, where scope is, there isn't scope in relation to the submissions, that a gap analysis would be of great utility to the district council.
And then it would be the district council would then have make a decision as to how and when they address those matters that are out of scope, if you like, or not on the table. They're part of our recommendation, and they may choose to promulgate a variation there and then, or take some other steps.
Yes, sir.
Okay. Thank you. That's good. I'll leave it there. Otherwise, I'm going to get onto some unsafe territory. Thank you.
Certainly, sir.
Thank you, Commissioners, and thank you, Ms. Wakara. I must say, in these uncertain times we are living in as planning practitioners, I found this morning's discussion absolutely fascinating, and really do appreciate the scope of your submissions and bringing these points to the table. I have one question really about the Tukituki High Court decision and direction to return the Board of Inquiry to consider the new MPS in that situation. I have to acknowledge I spent 5 years of my life promoting both all those matters, but just to confirm, that was both a plan change to the regional plan and a resource consent for a large storage infrastructure facility. Is there any difference, or was there any distinction between the plan change responsibility and the resource consenting role the Board Inquiry had in relation to what the High Court said?
I can't recall, sir, in my review, a distinction in relation to those matters. So I would say probably the best course of action would be for me to confirm, because just in my review of the decision, perhaps I skipped over those distinctions in looking for the, so confirm the matter and then include it in a supplementary along with submissions in respect of the decision that Commissioner Littlejohn has pointed me to.
Yes.
In the interest of time.
Yes, and I'd certainly tautoko the concept of preparing those supplementary submissions on this key matter for us, your assistance with doing that, following our discussion this morning would be of great assistance. So, and just thinking ahead, Ms. Wakara, staff have normally 2 weeks after the close of the hearing to produce their right of reply, and I'm wondering whether you might be able to have, I don't think you could, there's a verbal right of reply first, but perhaps those supplementary submissions towards the end of next week. I'm thinking maybe Thursday next week. Would that be appropriate?
Yes, of course, sir. I am happy to provide them earlier if that would assist the section for Bay office.
I'll just check with them. Just in terms of timing, I'm feeling that we may well be going on this part of the hearing into tomorrow. Yes, would that assist you, Ms. Macbeth? Those supplementary, and Ms. Young, those supplementary submissions on this matter before you deliver your verbal right of reply?
The verbals tomorrow.
Yes.
So maybe assist us for the written right of reply, but
yes.
A bit unrealistic.
So we're hearing that certainly the verbal right of reply tomorrow may not be enough time to really write those up and consider those. So I think certainly for the written right of reply, so Wednesday, Thursday next week would be fine to receive those supplementary submissions.
Certainly, sir. I'll aim for Wednesday.
Thank you very much, and just file those through the hearing administrator, and we'll get those. Everyone, we will take a break for morning tea. Let's just come back around 5 to 11. Thank you. Back, everybody. Yes, welcome back, everybody. I see Ms. Wakara is trying to connect audio, so we'll just stand by for her. Ms. O'Cora, just two preliminary matters before we get underway. In the room here, you're on the big screen, up in lights, and the video process comes and goes a little bit. So sometimes you go blank and then sometimes you come on. I think the people in the room have worked out that that's just some little glitch. You are being recorded and we are getting the full recording. So just so everyone acknowledges that. It doesn't last for long. Not only you, but other parties as well come and go. They've gone now, but we'll be back again in a moment, I think. There you go. So that's the first matter. And look, I would like to
Sorry,
welcome...
Stephen, just on that, I'm receiving the messages loud and clear. There haven't been any glitches at my end.
Okay, it's just on the big screen here that we've got the glitch. And look, Mr. Beard and Mr. Phillips, I'd just like to welcome you to the hearing. Can you just stand up and make yourself known? Yes. So you were programmed to be on first, but I understand there's been a bit of a travel delay. So look, we'll interpose you after Ms. Wakira finishes her legal submissions for the iwi. So if you can just wait patiently until then. I think that's the best place for Mr. Beard and Mr. Phillips to come in, Ms. Wakira, if you're okay with that.
Yes, sir, absolutely.
Okay, right, I think we're now moving to the draft MPSIB and the MBA. This is your next topic. Thank you.
Yes, sir. We can skip through to paragraph 28. I understand that submissions have raised the question of the relevance of these documents. I also understand from the tangata whenua submitters that you have discussed the relevance of the draft MPSIB with counsel for the department. And so I'm conscious of that. And in that regard, I essentially echo the position that has been put forward by counsel for the department, which is to say that case law has recognised that the draft MPSIB isn't to be disregarded. It's a matter that's relevant to the considerations before you. However, of course, the enabling legislation provides sufficient guidance in this case. And in that regard, I note that Section 6C that we're dealing with at this stage of the enabling legislation provides that protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna must be recognised and provided for. And I've also added the proposed language in respect of the NBA, which retains that language but also strengthens it. So I would rely on counsel, the discussion that you've had with counsel for the department in that regard and support those submissions. In relation to the draft MBA, I absolutely acknowledge that this is an exposure draft, and so to be caught up in the detail of the language at this stage, I think could cause some issues for the panel. The point, however, that I make is that it shouldn't be lost on the panel, and I don't suggest that it is, that the RMA is to be subject to some significant reform, and that reform, that there has been some clear high-level direction, similar to the strategic direction and the interim guidance that the panel themselves have offered about where one might take the reform. And that, I say, is a matter that is relevant and should be considered in the context of the decisions to be made by the panel. In that regard, I would draw your attention to the quote at paragraph 31, the explanatory material to the NBA calls for transformative change. That's the language that's used in that document, not my language, although I would endorse it. It states, the RMA has not delivered on its desired environmental or development outcomes, nor have RMA decisions consistently given effect to the principles of Te Tiriti or Waitangi, acknowledging that that is not the language in the RMA at present, but it is the intended language. Current processes take too long, cost too much, and will not address the many new challenges facing our environment and our communities. So the paragraph is directed toward a range of issues with the RMA as it stands, not just those matters that concern tangata whenua interests. However, there is express acknowledgement as in respect of these reforms that there are particular issues to be addressed in the way that the RMA hears from, responds to a Māori. And it's my submission that that broader context is relevant to the decisions to be made and reflecting on how the panel might do the same, acknowledging that that's about how you might respond to the issues. And so I also note, again, in terms of the some high-level direction of travel at paragraph 32, that the intended government reform objectives are outlined as including at 32C, give effect to the principles of Te Tiriti o Waitangi and provide greater recognition of Te Ao Māori, including Mātauranga Māori. So putting aside the issue of legal weighting there, the intent to be providing for the principles of Te Tiriti, to be providing greater recognition of Te Ao Māori and to be including Mātauranga Māori are matters that I submit, together with the other sub-clauses I've outlined that reflect those reform objectives, are relevant considerations and should therefore have a bearing in that context, acknowledging that, as I say, the text does reflect an exposure draft to the decisions to be made. So that's my submission in relation to the future focused resource management outcomes that are emerging from the strategic objectives and the relevance of those matters distinct to the express text. Acknowledging, I would say, as a final point, that the intention to use Te Oranga o Te Taiao and its synergy with Te Mana o Te Wai and with Hutia Te Rito in relation to the draft MPS does suggest a particular trend about how Māori concepts are incorporated within national direction documents and the intent in those documents for those concepts to permeate at a local level.
Thank you. We'll take some questions from the commissioners on this topic. Commissioner Coffin.
Thank you, Chair. My first question you've answered it because I'd asked the question of legal counsel for DOC about what weight or what status we should give the exposure draft of the National Policy Statement for Indigenous Biodiversity, and so you've concurred with that. So that's answered, I think, my first question about what was your view. The second one is, and it's probably more problematic, certainly for myself, is a number of the expert witnesses and evidence that's been provided to us, in particular parts of these submissions, rely very heavily on the draft National Policy Statement for Indigenous Biodiversity and the draft and parts of the draft NBA where it particularly suits their particular submissions. And I'm just finding the second part of that problematic because we're working within the RMA context. Any future legislation would most likely have transitional arrangements, and for those who might remember, this has shown our age perhaps, the transitional arrangements for the Resource Management Act and the Town and Country Planning Act, and that took at least 10, 12 years to see its way through. So I just wondered whether you had any, you've set out clearly, your current position, and there isn't much in terms of case law or other things that we can sort of look towards experiences, but what would be your guidance when, in terms of where these evidence briefs are relying on provisions of the draft MBA that's not been enacted yet? What's your guidance to us in terms of any particular, are we considering the line of travel as you've said, or are we giving any particular weight?
I would say, sir, that as I've identified, it's important to reflect on the fact that, as with the Town and Country Planning Act and the RMA, that this will be an entirely new framework that we're dealing with, and so to reflect on the fact that this reform is not something to be ignored, I think is important. I appreciate that to rely on express text to say this text suggests that a particular outcome must happen could result in some challenges for the panel in the sense that it may be that text subject to the consultation that is taking place changes over time. But the point in respect of concepts like te oranga o te taia or high-level directions about the need to restore the environment, in my submission, what they point to is that the RMA, in terms of its application to date, acknowledging any limitations that might exist and the need for reform to actually kind of push the RMA further in terms of the mechanisms that are available. But in respect of the mechanisms that you have before you, the reform is saying that the RMA is not delivering, and so that should be a strong direction for you to say that where the submitters are suggesting that an alternative approach might be taken that better delivers on the RMA, and their submissions are consistent with the line of travel of the reform, that would be an appropriate point for the panel to reflect on. Well, the RMA hasn't delivered to date. This is a proposal that submitters consider will deliver on those outcomes, and it's a proposal that is consistent with the high-level objectives that the government has said they're seeking to achieve, strengthening provisions in relation to protection of the environment being an example, and the stronger recognition of Māori issues being another. Then those matters are matters that I consider relevant and should bear on the decisions to be made. I acknowledge that relying on express text might be difficult, but where that submission really is about a improvement to the plan consistent with what is directed in the reform, I consider that you could still rely on that submission, notwithstanding the fact that it might parallel the text. It would just be a matter of identifying you're not doing so on the basis that you feel bound by the text, the express text of the exposure draft. It's on the basis that you consider that it's appropriate in terms of giving effect, or providing for those resource management matters and recognising that it's appropriate to do so under existing mechanisms.
Thank you for that. That's all my questions, Chair.
Thank you. Commissioner Littlejohn?
No, I don't, excuse me. I don't have any particular questions on this section of the submissions. Thank you.
Thank you. Commissioner McMahon?
Commissioner, you're on mute. Sorry, we can't hear you.
David, you're on mute.
Sorry, can you hear me now? Good. Right, sorry to disappoint you. No questions from me other than just to note that the NBA is not in the tent at the moment, and you know, was important to have regard to what it might bring. There'll be a process for dealing with that in due course. Whether I'm still practicing at that time is probably a moot point.
Yeah. Thank you very much, and I have no questions. Your next topic, Ms. Require.
Tēnā koe. So I turn to the Ecosystems and Indigenous Biodiversity chapter, use of Mātauranga Māori and ethnic identification. So in order to ensure that the tangata whenua submitted ways of planning for and managing the environment consistent with Mātauranga Māori are provided for within the plan, acknowledging that Mātauranga sits on a platform of generations of knowledge, practical implementation and wisdom. They have sought the use of Mātauranga Māori as an additional criterion, I understand, to identify Indigenous vegetation and Indigenous habitat. Now, I understand that the Council is broadly supportive and recognise that the Section 42A author has nonetheless acknowledged that amending the criteria in the author's recommendation is not considered necessary given that the history of the identification of that criteria through established Environment Court processes. And I do note that Ms. Bellamy's evidence from a planning perspective responds in quite a lot of detail in relation to planning matters, and so I don't intend to traverse that and would direct you to it. What I would say is that, as we know, there's no definition in Section 6C of what constitutes significant areas of areas and habitats. But that policies 1 and 2 of the NPSIB, acknowledging it's a proposed policy, do include some description of what that might mean. And in my submission, acknowledging the case law, the assessment has been determined as not one of strict legal test or established precedent, but in fact, it's confirmed that it is a factual determination to be made in the context of a planned decision. And so that's a decision that in my submission can be made. Now, whether or not Mātauranga Māori is an appropriate criterion, I consider will turn on actually planning concepts of whether or not it's sufficiently certain in relation to how it is to be used in the context of the SNA criteria. And in that regard, I do understand that through the planning evidence, some more perhaps refined language has been proposed into how, in respect of how Mātauranga Māori criterion might apply. I note, just really for completeness, that Mātauranga Māori is applicable in relation to this issue, therefore, on its facts and in terms of the assessment to be made about whether an additional criterion will be added, but applicable as a legal concept also. So to the extent that the case law to date has identified particular criteria, it would be able to be included as an additional criterion in any event. Though, as I say, the case law has confirmed that it's not about legal tests as such. It's about factual analysis and what's appropriate in relation to what significant natural areas and habitat mean. So I really wanted to provide that by way of point of clarity, and therefore would say that the question then about whether Mātauranga Māori is provided for becomes a planning discussion about how it might best be provided for.
Thank you. Have you covered the matters in section 40 and 41 as well? Because well, I think we'll stop at the end of this whole
yes. I understand that that with Council for the Department, there was a discussion about whether you could protect non-SNA Indigenous biodiversity, and the tangata whenua submitters did inform me that Commissioner Littlejohn may have raised a relevant case in relation to the Auckland Council, and so it seemed to me that this was probably that case. So really, for completeness, I thought I might include it in order that the commissioners had it before them, noting, of course, that Commissioner Littlejohn had raised it. But it was just to say that in that case, the court concluded that given the mandatory nature of Section 6C and the essentially factual description of the sites that do meet SEA in that case relevance, that they conclude that any site meeting the SEA criteria is in fact a significant ecological area under the plan, whether or not mapped. So I thought that might be useful for the panel.
Thank you for that. We'll take some questions, starting with Commissioner Coffin on this section.
Commissioner Coffin, you're on mute.
Just as well, I was just talking to myself just about where was that. So I've saved myself that embarrassment. Just in regards to Mātauranga Māori and SNA identification, this is a really interesting one to me because I've certainly been involved with, and I'm sure panel members have been involved with, either as a hearing commissioner or as experts involved in a number of projects around Aotearoa, New Zealand, where Mātauranga Māori is incorporated into different types of assessments. There are even specific assessments that have a quite focused Mātauranga Māori perspective on ecological habitats, areas, and species. And I just wondered in regards to this, because I've got a number of questions for some of the experts that are coming up about the criteria and how it might or might not fit. And I just wondered whether you had a particular view about if we were of a view to look at incorporating Mātauranga Māori criteria, what would then be the likely implications? In my mind, there is at one end of the scale a simple reassessment or evaluation of those which have already been proposed for scheduling. At the other end of the scale, a reassessment of all SNAs in the district and a number of options in between. And I was just wondering, from your point of view, where you thought the implications would be from what you're putting forward in your submissions.
I agree that there's with the spectrum that you've identified, and so that the starting point would be to reassess those existing SNAs. I haven't been provided with express instructions, unfortunately, sir, and this is the downside of being available via Zoom, because I could have otherwise said, can I quickly take comments from my clients about what they would prefer. So perhaps it's best to direct that question to them.
Yes, I've got those
but for me to say that
Yep.
in relation to the implications, I would say that you could do the spectrum that you have identified, I would agree with.
Just the other thing, us as commissioners, we often do homework at night, and one of my fun bits of homework was just to see if the RPS was helpful in regards to all matters Māori, particularly Mātauranga Māori. I couldn't find one reference to Mātauranga Māori in the RPS. Now that's probably a little bit of an indictment on the RPS, and perhaps a need to review it. But whether there are any other documents, you haven't really identified them there, but there are any other documents that you're aware of, or perhaps we can pick that up in the expert evidence that might give us some, it might not be that specific term, because I know the RPS has a very much of a focus on Section 6E in regards to things Māori, and it repeats the legislation over and over again ad nauseum. It's not helpful in getting into what are the ways in which that might be expressed, including Mātauranga Māori.
Yes, sir. I would say there that it is unhelpful in the sense that those legislative terms are repeated, but nonetheless that Mātauranga Māori is relevant under the legislative provisions that are repeated through the RPS. In that regard, I have sought to. I think it is another question for the planners who have been looking closely at those provisions. My instructions were to identify in relation to any comments that perhaps the court-based criteria might create limitations about what the panel could do to address that specific issue.
Sure. Hey, thank you. I'll leave questions in regards to the non-SNA Indigenous biodiversity for some of the experts. Thank you.
Thank you, Commissioner Littlejohn.
Kia ora. Another section of your submissions I very much enjoyed, not because you referred to the decision that I was hinting at, but yes, you are correct. That was a case. I wouldn't recommend reading the whole of it because it ended up in the High Court and certain aspects of it changed. But certainly on this point, the very mandatory direction of Section 6C and NZCPS did create a bit of a straitjacket for the council. The interesting dynamic there was, and we don't find it in Taranaki, is that the SNA or the SEA schedule in Auckland had two purposes, and they sometimes in different directions. One was to protect bush, but the other was to operate as an incentive for rural landowners to protect said bush in order to get allotments. So the council was to that extent disincentivized from actually mapping all of the SNAs, because in doing so it would, what it thought, create a gold rush of new allotments in the rural zone for lifestyle living. And so they were in a bit of a bind, really. And so the argument very much was focused on that restorative incentive-based mechanism. The interesting thing I find with Taranaki, though, is that unlike Auckland, Taranaki seems to have a much bigger safety net of non-regulatory methods to encourage restoration and planting and fencing and stock exclusion, whereas there don't seem to be the same palette, to use the Environment Court's phrase, of methods to assist landowners to actually do this additional work. And certainly the evidence we've heard is that there is a huge culture in Taranaki, which I wouldn't say you don't see it in Auckland, but in Auckland it's motivated for a different reason, and that's land value gain. Yeah, so very interesting. So I appreciate that, and it does cause for us, I think, an interesting topic of discussion, because of course we've got a lot of people who've said my bush is already protected by another mechanism. Does that necessarily exclude that piece of Indigenous vegetation from having to be scheduled under these criteria in the plan? So it's something that has been a real theme of the hearing, which we'll spend a bit of time thinking about. So thank you for that. The significance criteria, I must say this is something really interesting for me. I don't know whether you're familiar with the original case where these criteria came to existence from. It was the Minister of Conservation in the Western Bay of Plenty District Council. And it was one of the first cases I ever did pro bono for Forest and Bird a long, long time ago, in which the late Judge Bollard recognised that there were these scientific or, Western science values that we use to measure bush against, and that's what gives it the significance or not. And I guess it's an indictment on some of the criticisms you've laid at the feet of our resource management system, that in that case, there were no iwi or mana whenua involved. And at least for 2 decades now, past that decision, no one's really gone there and said, well, significance as it's used in Section 6C is not qualified by it being Western science significance. And so I think there is a really strong argument you could make that you don't read the values in Section 6 as sort of chapters of a book. You look at them in a more holistic and integrated way. And it was certainly some of my thinking last night was that if you read Section 6C and 6E together, then you've got all you need to be able to bring to bear Māori values in the recognition and identification of Indigenous vegetation and Indigenous fauna. So I guess I'm sort of wearing my heart on my sleeve there, and that you probably don't have to argue too hard for me to conceive of an evolution of how we see these concepts in Section 6. The question Commissioner Coffin put to you about what it actually means, though, my understanding of the criteria as they're currently drafted in Eco Policy 1 are that they are disjunctive. So provided you qualify, if the bush meets one of them, then that gets you in the schedule. So from my perspective, and I will talk to your witnesses later, it's not so much a case of going back and looking at everything that's already on the schedule. It's looking at those that are not on the schedule that might otherwise be if there was a different criterion in the policy that reflected identifying Indigenous vegetation and Indigenous fauna that had special values to tangata whenua. And that's certainly something I'm going to explore with your witnesses about how many areas are not there that might otherwise be, because at least until you potentially add another column to that schedule with holds special value to tangata whenua as a column, and you allocate the ticks, you could potentially do that at another time, knowing that at least in the interim period the vegetation is protected. So that was less of a question and more of a thank you for your submissions, because I think there is an interesting opportunity there to actually do what the Waitangi Tribunal said in 2011 and make this Section 6 actually a bit more of an integrated proposition, even if it might be too late now that we've got a whole new legislation coming in. But no, I appreciate that. And let me know, have you come across any other, I haven't come across any other cases in which that concept of significance in Section 6C has actually strayed outside of those Western ecologist values, certainly not even in the Friends of Shera Swamp, the West Coast Regional Council case. They simply said the propositions are relative, but they didn't go and say they necessarily are more than objective in the science sense.
No, I agree with you, sir. I did take a look, but couldn't find any case law where you had a Māori party that was advancing an additional criterion. So I would agree with everything you've said and note that I consider this as an opportunity for the New Plymouth District Council to be taking some leadership in respect of a Tauranga Māori-based criterion that provides the sufficient certainty that's required in the context of a plan, but also meets the expectations of tangata whenua. And to that end, would just simply add that at times I make comments as to Section 6 about how, as we know, there isn't a hierarchy, and so Section 6A, it doesn't prevail over B, for example, but do note that these are competing principles, and that has been acknowledged in relation to the RMA, and it's about weighing them, weighing in the context of a bigger decision to be made. And I agree, though, that in this case, the principles don't compete. They can be reconciled in a way that supports the intent in relation to a Tauranga Māori-based criterion.
Okay, ngā mihi, thank you.
Thank you, Commissioner McMahon.
Thank you, sir. Thank you, Ms. Waikura. I wondered whether, I mean, you indicated earlier that it wasn't necessarily a case of just referring to the knowledge base of Maori and the criterion, but there could be different ways of expressing that in the criterion. And I wondered whether you'd had a chance to have a look at clause number 5, which is the addition to policy 01 that's been attached to, I think, to Mr. Marco's evidence. It's the track change version. Firstly, have you had a chance to?
Pulling it up there.
It's on page 5 of the amended track change.
Let me just pull it up, sir, if you wouldn't mind just giving me a brief minute.
Can you just remind us all of the reference again, Commissioner McMahon?
So it's page 5 of the track change version of the provision, and I assumed it was attached to Ms. Marco, but it may well have been one of the other planners. It could equally have been.
I don't have any page numbers on Ms. Marco's.
No, it was the last document in the bundle, sir. The blue and red track change version.
It doesn't appear to be any blue and red track changes in Ms. Muckle's evidence.
No, I think it's the statement on
Ms.
behalf of
Bellamy's or Ms. Pukokoda?
Yes,
Oh,
I think that's all. Look at that and see whether that's right.
Yes, there are some blue and red track changes.
And if you go to page...
Would it assist there if I shared my screen so that
super.
where I didn't... Perhaps I'll just find the reference and then I can share my screen, and then those sitting at the hearing can follow along with us. Could you provide me with that reference again, please, Commissioner McMahon?
It's page 5. And it was clause 5 in red. So it's it's above Echo New.
Yes. And I shall share my screen now, assuming that I'm able to do so.
Now, even though it's not labelled, I assume that is actually policy, Echo Policy P1.
Yeah.
Sorry, you.
Yes, got a thumbs up here, so that's right.
Yes.
Yes.
Okay, So my question is that criterion doesn't refer specifically to Matarangi Maori, but you'd indicated earlier in your submissions that you'd understood that there'd been a sort of a reworking of how that concept could be delivered as a criterion on PC 01 or Eco Policy 01.
Yes. And it's my understanding, based on review of the evidence, and I understand, I mean, they can confirm this, but Ms. Bellamy, Ms. Mako and Ms. Hokopoda have conferred and come up with this particular provision as meeting their expectations in relation to a form of criteria on a mātauranga Māori.
Okay. Have you so have you addressed your mind to whether that was within the scope of relief sought?
Yes, sir, on the basis that the request was to include a reference to Mātauranga Māori in relation to the submission, but that what routinely can be met in response to tangata whenua is a broad reference to Mātauranga Māori would be far too vague and unambiguous from a planning perspective. Not to say that that might be the case in every instance, but if you're directing someone to particular criteria, that's often the response that tangata whenua are met with, and on that basis, a more specific response that is directed toward addressing those aspects of Mātauranga Māori, mahinga kai, rāranga, rongoa are noted in this case, I consider as within scope.
I'll have some, thank you for that, that's really useful. I'll have some questions for the three planners in relation to that, and I can signal them now. I'm just looking for a linkage from that new policy upwards to the objectives, and to what extent there needs to be, excuse me, any consequential changes to the objectives to align with that new policy. And similarly, a linkage down as to how that policy is given effect in terms of the methods, rules, standards, and other provisions of the plan. So just a bit of a heads up to your planning witnesses that sort of line diagram is something I'm very interested in exploring with them. In the meantime,
I'm sure that heads up is appreciated. Apologies.
Yes, thank you. In the meantime, I just wondered what we make of that new proposed policy. I mean, in one sense, as Commissioner Littlejohn said, it doesn't affect those SNAs and other Indigenous vegetation that's been identified, either specifically as an SNA or in the coastal environment. It's really about what's not on the list or what's not captured by a process. And if the panel was of a mind to include that policy and there was attendant linkages back up to the objectives, that suggests that the district plan doesn't contain provisions that might give effect to that policy.
Sorry, sir, I'm not quite following you. You're saying that you consider that inclusion of policy would mean, oh, sorry.
I'll try and rephrase that more clearly. If the policy was adopted by the panel and recommended accordingly, is there a possibility then that there is an absence of methods to give effect to that policy, particularly in relation to areas of SNA that may otherwise have been included that haven't been included? And if so, what's the remedy?
If I understand your question correctly, I would reflect on Commissioner Littlejohn's point that the current eco policy is disjunctive. So to that end, in fact, he made the point that you're really adding an additional policy there, and therefore it would be a matter of identifying further SNAs.
Yes.
On the basis that those SNAs that currently exist there is in you'll be able to take the benefit of those SNAs as they relate to Mātauranga Māori issues, not having to revisit them.
I understand that. What I'm not clear on, though, is where there are potentially SNAs that haven't been identified, either specifically or which are captured by the coastal environment rules, and that would have otherwise been included in a scheduling approach if that policy was in place. And so what I guess I'm asking is there a potential gap? And if so, what's the remedy for identifying that gap if the panel was in mind to run with that recommendation, that new criterion?
Oh, yes, sir, I understand. Yes, so I agree that there would be a gap, and which is why the Tangata Whenua have raised the matter, and so there will likely be some additional SNAs, and so it would be a matter of a further process to identify those SNAs, either through in noting the length of that process. One could contemplate a re-notification in this context, or one might consider that it's appropriate to simply identify that the matter would require further action on part of the council at a later time.
Yes, okay, I understand that. I guess, again, just signalling for the planners that are to follow, one of the questions I'd like them to consider is the extent to which the new rule that's being recommended, which is for any Indigenous vegetation that's not captured by an SNA, not within the coastal environment, but involves the clearance. And I think the rule is a restricted discretionary that's been recommended by the Director General and supported by iwi. To what extent would that give effect to this new criterion, and therefore potentially avoid the need to go through another exercise of identification of SNAs that gives effect to this criterion? So in other words, would the resource consent process provide the answer if that new restricted discretionary rule was in place? Now that's a question for the planners, but if you've got any comments from a legal perspective, I'm happy to hear them.
My experience in terms of comments from a legal perspective would be that where there's the ability to provide expressly for a matter within a plan rather than rely on the discretion associated with the restricted, albeit limited discretion if it's a restricted discretionary rule, or the broad discretion associated with a discretionary rule, that clarity within the plan would be preferred on the basis that it provides a much clearer touchstone for tangata whenua advancing in the relevance and importance of protecting Indigenous biodiversity, and allows them to take comfort in that kind of the firm aspect of plans, not having to participate in every consenting application that they consider might contravene that issue from their perspective.
Yes, that potentially could involve quite a bit of work, presumably, in terms of an inventory of the resource, checking, I guess checking firstly those SNAs have been listed already, and checking every other piece of Indigenous vegetation outside of the coastal environment.
I appreciate that, Sue.
Okay. Yes. Okay. Well, that's a heads up for the planners. That I'll have those questions for them. That's all for me, sir. In the meantime.
Thank you very much. Ms. Wakara, I presume you've caught up with directions of the panel that we've asked the planners who have given evidence in this topic to conference, and that Ms. Macbeth will be organising that. Yes, and probably just for yourself and also for the expert planners, they'll also be aware that we're being pretty strict around the need for Section 32AA analysis from the planners, and that's quite important when policies and rules are being changed and other methods, just to work through what that might mean from a Section 32AA perspective if we were minded to accept various submissions. Just from my read, I haven't seen that in the three planners' briefs of evidence that I've read. I've seen some brief commentary from Ms. Bellamy along those lines in a short paragraph, but I think we do ask that the planners from the iwi collective do provide that and have that issue prior to that joint witness conferencing, because I think that does bear on the discussion the planners will be having. So just to signal that, and the planners can address us on that particular matter, but just see whether you had any thoughts on that, either the process or the 32AA necessity.
No, sir, that process seems sound.
Thank you. Shall we move on to the next topic, natural features and landscapes, please?
Yes. So my submission 42 through to 50 are really a plea for limited re-notification in relation to Pukeiti in order that it is able to be included within the ONFL associated with Taranaki Maunga. So it's no challenges to scope or jurisdiction. It is, as I'm instructed, a matter that can be discreetly addressed, acknowledging that those parties that are affected directly, landowner parties, Taranaki Regional Council and Paraninihi Kiwai Tōpura, must of course participate in any decisions, but that the position of the tangata whenua submitters is that it was an omission on their part not to include Pukeiti because Pukeiti is part of the Taranaki Maunga landscape that otherwise shall be provided for in relation to that particular ONFL, and that recognising that, well, in my submission, recognising that the issue then becomes one of, was the matter on the plan, and we've only had a further submission on the issue and no original submission, but then was the matter fairly and reasonably raised in relation to scope, then in my submission, if the matter is limited, if the issue is limited in its effect, then it's an opportunity for the panel to provide for limited re-notification. And on that basis, the tangata whenua submitters are willing, recognising that where this ONFL will really bite will be the provisions that are attached to it. They acknowledge that it might be that some bespoke provisions that recognise the specific protected ONFL status and the mana of that status, but acknowledge the need for that whenua to be workable in relation to the existing landowners, and perhaps cater in the same way or do not include setbacks in relation to neighbouring landowners, would provide for a limited set of persons that would be required to be re-notified in this case and to engage in the discussion. So that's the broad proposition that I am proposing, and the question then, putting aside that issue, and you'll have your view, is the limited re-notification in this particular case. The question then becomes, well, is Pukeiti actually of such status and significance that it would otherwise be included in the ONFL? And so I addressed that matter at the submission commences at paragraph 45. So I note that, again, just as with significance and the discussion we had prior in relation to significant natural areas, that outstanding is not defined in the RMA, and however a substantial body of case law has arisen in relation to it, and I draw your attention to two key points arising from the case law. One is that it's important that natural landscapes and features are viewed in their full context. And the second is that at 45B, the identification of outstanding natural landscapes does not depend on the protection that these areas will receive. So one first identifies ONLs and then concerns themselves with what would it mean in relation to protection. That was the decision of the Court of Appeal, Man of War, in relation to a particular issue. And that is so that the policies do not drive the identification of ONLs, but it's done in the reverse. Now, the evidence of Ms. Hokopoda, and I've summarised that at paragraph 45, demonstrates why the request to include Pukeiti has been made. And the tangata whenua submitters are of the strong view that the landscape ngā maunga o Taranaki must appear in its full context. Now, for clarity, the Taranaki Maunga, ngā maunga o Taranaki isn't inclusive of Pukeiti in terms of the Maunga negotiations at this stage because it is privately owned. And so part of the history of Pukeiti is that it hasn't been included in the past because of its private ownership. But from an ON, that doesn't divorce its relevance in terms of an ONFL approach. So for the tangata whenua submitters, they say from a taranaki perspective, it's part of the wider landscape of tupuna maunga that includes taranaki, kaitake, pawakai, paritutu, ngā motu, tapuai, and mikotahi. And I understand that mikotahi is another distinct issue that will be discussed through the course of this hearing also. Pukeiti is very significant for taranaki iwi uru descendants, and it is as much part of the taranaki, kaitake, pawakai landscape as mikotahi is part of the paritutu, ngā motu, tapuai landscape. So really, the detail of my submission points, I know you have read, but that is the plea. It's that in relation to the matter, we're not questioning scope, we're asking for a very limited re-notification. Of course, acknowledge that the view of Taranaki Regional Council will be important in the context of any decision, and that the tangata whenua submitters intend to have those discussions but have not been able to, at least from my last discussion with them at this stage. They have talked with the landowner Paraminehi Ki Waitotara, PKW, as they're referred to at paragraph 49A of my submissions, and I understand that a letter has been produced that's in support of an ONFL landscape status, while acknowledging that they're willing to discuss what that will mean in relation to any associated provisions. I'm not sure if you have that letter, but it will no doubt be produced by, if not, by one of the tangata whenua submitters. And I understand there was hope that a PKW representative might be able to speak to it, albeit with a short notice. They preferred to provide a letter for clarity as to their position in the event that someone couldn't attend. And the final point is to note that the proposal is intended to resolve the first principal matters that otherwise would be contravened in respect of RMA Schedule 1.
Thank you. You've addressed specifically Makahi as well, and as there's two issues. There is a submission about...
Sorry to interrupt you, but could I just note that I think I might have come to a time limit on my headphones, and so I don't want to miss what you're saying, and so what I'll do is just change to computer audio for a period, if that's okay with you.
Sure.
Thank you,
Yes.
so 1 minute.
You back with us now? I'm very familiar with this sort of problem. I get one of my children to fix these issues for me. Can't hear you still there, Maya. Just take your time. I think perhaps we'll just take a short adjournment while Ms. Rokaya sorts this out. I'll just thank you very much.
There we go. I'll allow you to make a comment. Sorry.
I was just telling there's people here that I'm very familiar with those sorts of challenges myself. No problems. I was really going to ask them about, there are two ONFL issues for tangata whenua submitters. One is Pukeiti, the other is Mokatahi. Now there is definitely scope on the Mokatahi one. It's just Pukeiti one that you're looking for a new process essentially.
Yes, a new but... Oh, sorry, sir.
Yeah, you go.
Oh, yes, sir. A new process, but recognising that the intention is for it to be a limited re-notification on the basis that the discussion would take place with the affected landowners in the first instance, and then to discuss what whether or not it's considered they are comfortable, and then next any provisions that might attach. And so that would, as I am instructed, limit that re-notification process to discussions between the tangata whenua submitters and PKW and the Taranaki Regional Council only.
Thank you. Right, just handing over for questions on that topic to Commissioner Coffin.
Yeah, thank you. Can you hear me okay?
Yes, I can.
Yes, good.
This one's an interesting one. Perhaps it's not couched as a question, more of a comment, and happy for you to add to that. And it just seems to me that obviously Puketi would have been advantageous if we'd had a landscape assessment for the district which included this area, and then we could consider it with no doubt, saying yes, it meets the criteria, and why is it or isn't it included in the schedules. In the absence of that, it seems to me that there should be a process for doing the assessment, because one of those criteria is the values to tangata whenua, and that's, I think, been clearly articulated. But also there's a number of those other criteria which I think inferred by the values to tangata whenua do cross over into those areas. But in the absence of a landscape assessment qualifying that, it just makes it sounds like it's a bit of a subjective call. And I just wonder, even if the landowners, for instance, agreed and said, yes, we think it is, there's still, I think, in my mind, there's an absence of an assessment that says, yes, these other landmarks have met that particular test, and this is equal to that. I just have a question about whether, if we were to follow the process as you've outlined, whether we'd still be back at square one, saying there hasn't been an assessment by experienced qualified people to do those, including the assessments of the value to tangata whenua. It's a no any foul. So whether you had any comments regards that?
So I think that's a very good point to raise, and it's a matter that I can take instruction on. My preliminary comments acknowledging I'm without instruction and without the benefit of discussion with the council would be that it would be useful for tangata whenua submitters to discuss with the Section 42A author whether that assessment might be able to take place as a part of the Section 42A author's further thoughts. I acknowledge that from a tangata whenua perspective, their view is that part of the reason why Puketi has not been included is simply because it's been a wrap-up and inclusion of the, as it stood, Mount Egmont National Park, and then assessment has been done on that basis. And therefore, it's really, the assessment would be about ensuring that it's included rather than any prior decision about not including Puketi on the basis of landscape expert views. So
yeah, that certainly seems to be my read of it. On the face of it, that's what's been done. Yeah. Okay. I didn't have any particular questions in regards to this, Chair.
Thank you, Commissioner Littlejohn.
No, thank you. I tried to have a look through the submissions and on the mapping and on the chapter, and couldn't see anything there. So it's something we'll have to consider. Thank you.
Thanks, sir. That's appreciated.
Thank you, Commissioner McMahon.
Yes, thank you, sir. Ms. Waikara, I'm just one question, and that's about the limited notification process. I must admit I haven't come across this this concept before, and I just wondered, is it first and foremost, is it a truncated first schedule process, or it sit outside the first schedule?
I think it would be a good matter to discuss. I would see it as it's part of your existing process. It's simply a re-notification within this first schedule process, and where this issue has arisen in the past, where I've participated, councils have had a particular view about how they might run a particular process. Often that may have come up in the context of a matter for which there is scope at a broad level, but the proposed provisions provide a level of detail, and the concern is that you might inform residents of the level of detail, acknowledging that there's a high level scope. And so the council officers have identified, we will provide a public notice, re-notifying at this stage, we'll call for any submissions based on this timeframe. So it really does mirror, but through a truncated process and limited to affected interests or parties, the process that will have already been undertaken in respect of the PDP.
Okay, I think I understand that. So it's a first scheduled process, not on speed. It's a process that will be limited to just 2 participants, PKW and the Taranaki Regional Council. Is that what you're saying?
Yes, sir. And of course, I would advise taking the views of the New Plymouth District Council to the extent that there might be other landowner interests that the tangata whenua submitters are not aware of. But yes, my understanding is that it's just these 2 parties that have landowner interests in Puketi.
Okay. So just help me here. What would actually be notified?
So it would be a limited notification in relation to inclusion of Puketi and where appropriate, the inclusion of particular plan provisions. Provisions in respect of that Puketi component of the broader ONFL. I would see that as being at a very high level the type of language that might be included in any notice.
Okay.
Because
okay, and so who would have an opportunity to lodge an initial submission on that?
So it would be limited notified to Taranaki Regional Council and PKW, and therefore they would be the 2 parties that would have an opportunity.
Yes. Would there be?
And tangata whenua, I'd say, sorry. Tangata whenua submitted on the basis that they've called for it.
Okay. Would there be an opportunity for further submissions on any submissions received, or is that redundant?
I'd say I think that the process would be best preceded by a meeting between the parties to truncate the matter. So I would anticipate that further submissions wouldn't be necessary on the basis that there might be a conferral and then the ability to say, we have discussed with, for example, if you're Taranaki Regional Council, we have discussed with the landowner PKW its interest and position, and therefore in relation to that we make the following comment.
Okay. I'm so sorry for all the questions. It's just
of course, no.
I'm not familiar with this process. Can you point the panel to any examples of where this truncated process has been used midstream, so to speak?
So I acted for Waikato Tainui in relation to a similar issue in respect of the request that the Waikato River be granted ONL status, outstanding natural landscape or feature status, and an issue arose. So there was the distinction there was that there was clearly within the original submission a call for an ONL status, but a number of other options became available that were clearly not within the scope. So one was talking about the concept of an outstanding cultural landscape as that had begun to be developed within case law. And so those other types of matters were raised by Waikato Tainui at the hearing, and the panel made the decision that in relation both to issues of whether or not it might be an outstanding cultural landscape that is proposed or otherwise, and also in relation to the detail of the proposed provisions, that those matters should be discussed between Waikato and the council. They should produce some provisions that clarify essentially the revised relief sought, and that together with a high level public notice identifying the matter should be limited notified to landowners who live adjacent to the awa.
Okay.
Because the real issue was setbacks in that case. And that was the position that was taken.
Yes, so that was in the Waikato. What was it?
It was the Waikato District Plan, sorry.
And is that process, did that process follow, and is it now completed?
Yes, that process was followed, and I'm not sure if the decision has since been issued. I can follow up with my client in relation to that. But the process was followed. Further plan provisions associated with the status were identified by my client, the determination, as I recall, was that it become an outstanding natural feature. And I'm not sure whether the entire hearing has concluded, and therefore whether a decision has issued or whether a decision was issued in respect of that particular hearing. So I can confirm that, sir, and come back to you.
Thank you for that. That was all for me, sir.
Thank you. Probably just follow on from there, Ms. Wakaira. In the Waikato District case, did the hearings panel issue directions? Well, I have a minute. I'm just mindful that we've got a recommending role, and I don't think we've got the powers to issue or undertake this. So just perhaps, just a question from that, and then I'd like to seek some clarification from Ms. Young in terms of New Plymouth District's knowledge, position, initial thoughts on this matter. So first, if you could come back to me on the mechanism that the Waikato District example arose would be good.
Certainly, sir. In relation to the question of a minute, I must confess that I can't recall, on the basis that the council were open to the re-notification, and so it may have been that a minute was not required in that instance, because the discussion was had at the hearing, as we're doing now. The council was on board with it, and so in that regard, council officers indicated an intention to limited re-notify. So I would have to double check whether a minute was issued confirming that, or whether the minute was simply that in relation to this particular issue, the submitter intended to confer with the council, because I take your point about your role in the matter, and am conscious too that I think the logical next step is acknowledging Ms. Young will provide a preliminary response for a discussion to be had between the tangata whenua submitters and the council, as well as the landowner parties, about the option, and perhaps we could, if that discussion can happen relatively quickly, we could come back to the panel with a proposed way forward.
All right. Well, we will need some further advice on this, including from the council's solicitor, I think, as well, because this is quite a key procedural matter. Do you see this as distinct from the Waikato Regional Council plan change process, where, as requested by, I think it was the Thames Ngāti Maru, not sure, requested a re-notification of was it the whole plan change in that case? Are you familiar with that one?
The Ngāti Maru case, no, sir, but I'm happy to.
I can probably fill in the chair, because I was involved with that plan change. I don't know if we want to do that now, or we can do that in...
Well, no, I am intrigued by this, and just from a process point of view, I'm aware that plan change 1 was re-notified, but was that limited re-notified? Was that the whole shebang?
It was the whole shebang, and it was notified, but in a geographically specific area.
Oh, are you referring to plan change 1 to the Waikato Regional Plan Commissioner Conference?
Yes.
Oh, yes. So that was in relation to Ngā iwi o Hauraki.
Yep.
And it was a concern that it was really a question about the Waikato and Waipa catchment also covers the erohe, and matters of relevance to them weren't included, yes. And so that was a variation.
Variation?
Yes.
Okay, yeah, by way of variation. Right, and look, I do also, the back of my mind, think that Queenstown Lakes, in relation to landscape matters around Wakatipu Basin, did take a pause in their process, and may have re-notified something there as well. So yeah, this is a reasonably significant procedural step for us to consider. So we just need as much background advice before we minds to this. That's good. And just moving on to case law, One of the other cases I'm aware of is a Queenstown Lakes case. It's the Upper Clutha Environmental Society Incorporated. It's a Judge Hassan interim decision. And that to me seems to be quite relevant because it's really around the values that contribute towards an ONFL. And they made it very clear it was, while outstandingness was not defined, my read of that case was that it's the sum of the values which brings things together. So are you familiar with that case, and is that relevant to us, do you think?
Is that the case that talks about the not immediately familiar as such, but I can speak to it, but in relation to the particular values, I know Commissioner Coffin will be able to speak to, you've got your associative values where tangata whenua interests come into play, but then you have two other categories of value. Perhaps you can help me out, Commissioner Coffin, that will be relevant. Oh, you're on mute, sorry, sir.
You normally have those natural science factors. You're thinking about the bones of the earth, the geology, ecological science, the biosphere, and then you have the human aspects of aesthetic values, memorability, naturalness, and then a whole range of other values.
Yes, so biophysical values, associative values, and the naturalness values, aren't there? Yes, so those are the kind of three categories that I understand are relevant, and however, to the extent that pukeiti is not natural in a sense, the case law has confirmed that the notion of a site being fully natural and pristine doesn't preclude the ability for it to be considered an outstanding natural landscape or feature. So I can't speak specifically to the case, sir, but I'm happy to make sure that I can do so in a supplementary.
Yes, have a look at that. I'm particularly interested in how that might apply to Mokatahi, which has these, from my reading the evidence, these strong cultural values that contribute to its outstandingness and just the whole, so if you could have a look at that case and provide us any thoughts,
sure,
your supplementary submissions, that would be helpful. Look, thank you for that. Plenty of food for thought.
So, Mr. Chair, I just had a supplementary question. It was something that I was going to ask the experts, but I'll raise it now, and then they can probably hear it. Ms. Wakaita might have some comments. Is that okay?
Sure.
Yes, certainly.
Just in regards to pukeiti, I'd made an assumption that the pukeiti was requested by tangata whenua to be included as ONFL as part of Maunga Taranaki and ngā maunga tupua, and I just wanted to test that my assumption is correct, or is pukeiti being forwarded as a ONFL in of its own right?
No, sir, it's as part of ngā maunga Taranaki, which is to respond to both your question and Commissioner Daish. In terms of the relevance of those values, traditionally tangata whenua cultural values have only come in under one of the three limbs being associative values, whereas of course, notwithstanding that there'll be a question as to naturalness and other biophysical matters, that's where the cultural value association has sat. But yes, sir, and that's why I consider the cultural values, of course, are relevant in relation to that three-pronged test. But the question of what outstanding naturalness means, what an outstanding natural feature or landscape means in the context of ngā maunga o Taranaki will be a critical point for a landscape assessment to determine also, and that's the context in which tangata whenua bring the matter to bear.
Yeah, because I was thinking if any assessment would be done, it would need to be probably done for the maunga with pukeiti as part of that context.
Yes, so I had made an assumption that there may have already been an assessment done, but just as relates to the former Mount Egmont National Park, so it might be a question of, without saying tacking that on, of being conscious of reflecting on the assessment with the pukeiti inclusion.
Yes, certainly, that's what I was just thinking. Thank you.
Ms. Young, is there anything you can say at the moment, or do you need to have some discussions over lunch and perhaps come back to us with any thoughts?
I don't think there's anything I can say. I think we need to get legal advice in the first instance.
Yes.
No.
Yes. So perhaps if you could take that advice and address us in your verbal right reply, that would be helpful. Thank you. All right, moving on to the last topic, I think, all but one.
Yes, sir. The very last topic really was just to address an issue as to scope that I understood arose in relation to the question around the scheduling of water bodies or significant water bodies. The issue was that there are, of course, provisions attached to the proposed schedule, putting aside what it's called. And in that regard, the request of tangata whenua submitters has been that those particular provisions would attach to all water bodies within all zones. And the matter was raised by the relevant section 42A author as not being within scope, and there was a concern that affected parties may not have had the opportunity to be apprised of the proposal. So really it's a what does the submission say question as to scope, because of course you'll have to make your own decisions about the merits, but this is simply, my submission is simply to address the scope issue. So I believe, sir, that we can, because you clearly have talked at length about scope in other contexts, that we could skip to paragraph 7 of my submission to simply take you to the Te Kahui o Taranaki submission, being not the only submission making this request, but the clearest submission making this request. And in that submission, we flip over the page to page 18. It states, all water bodies in Aotearoa that fall within the New Plymouth district are considered significant, and provisions must be designed to provide for te mana o te wai, recognising that all water bodies have their own mode, and the specific relief sought is amend the water bodies section to apply the provisions designed for significant water bodies to all water bodies. In my submission, sir, that is unambiguous and fairly and reasonably raised. So there's no suggestion as to lack of scope, sir. The question then becomes one of merit, and for the panel to determine the proposal in that context.
Thank you, Ms. Rukaira. Commissioner Coffin.
Take me off mute first. I did have a question. This is in regards to the interplay between some of the Part 2 matters, particularly Section 6E, which is really talking about providing for relationships between Māori tangata whenua and ancestral lands and those other natural resources. 6F, which was really talking about the protection of heritage. And then we also have Part 2 recognition of public access, and I'm just looking at them as a whole. There's obviously in regards to the submissions we're hearing about wanting to restrict public access to some places, and my thought is for good reasons, for a number of good reasons. How do we resolve that tension where we're looking to provide public access as a matter of national importance, but we're also trying to provide for the relationship tangata whenua have with those natural resources, as well as protecting. So I've been looking at them as a tandem of things and trying to see if there's a way that you're able to meet all of them rather than picking one over the other.
So I think you're asking me to do the impossible to the extent that they might.
That's what lawyers do, don't they? We're in trouble, we go to the lawyers. Yeah.
But my answer was going to be that if you find that the position is irreconcilable, then you are able to lawfully choose one. They are all of the competing principles. That's the discussion that I had with Commissioner Littlejohn earlier. And therefore, it's a question of weight to be given to the relevant principles in the context of the particular issue. So where you decide that public access mightn't be provided in all cases because Section 6E proposes that it's not appropriate, then that is a decision that is available to you, because you're still recognising and providing for public access in the broader areas within the plan. It's just that you've identified that emphasis and prominence should be placed in relation to Section 6E with respect to certain public access areas.
Yeah, and I probably perceive there's using the policy framework. So if you had objectives that was being consistent with those Part 2 matters, but then you had policies and particularly rules which helped define the places in which they might apply more often than not, that would be a suitable approach. I just wondered, is that consistent with your thinking? Where you might not necessarily resolve the tension at the objectives, the high level, you can actually do that with a little bit more nuance further down.
Yes, sir, and that's a part of reflecting those local issues as they relate locally.
No further questions.
Thank you, Commissioner Littlejohn.
No, I didn't have any other questions. I think there is scope. It comes to us to look at what that sort of means in terms of the merits of the submission across the board. But thank you for your submissions.
Thank you, sir.
Commissioner McMahon.
No questions. Scope, I think, has been demonstrated. It's now a merit analysis.
Thank you. So thank you, Ms. Wakara. I've commented before about the store that the panel does put on good legal submissions and the discussion around these, and I'd like to say thank you very, very much again for your considered submissions. And also, I know it's not easy to talk about all these cases and the prodigious brains that lawyers have about sort of cases and all that sort of type of thing just never ceases to amaze me. So thank you very much. One last sort of, I suppose, comment from me about the Section 32AA analysis I signalled. We have appreciated the way some of the practitioners are putting these forward, and there's quite a good example in Ms. Ratt's latest evidence for Transpower, where she does these 32AA analyses can be difficult to do, but just the way that was structured might be a useful thing to have a look at in terms of going forward. So thank you very much. Is that all we have from you?
Yes, sir, that concludes the submissions for the tangata whenua submitters on this hearing, acknowledging that I'll be available, albeit with my video off, if there are any further questions that you have arising from the evidence provided by tangata whenua submitters.
Thank you very much.
Tēnā koutou.
We would now like to interpose, as I signalled, Mr. Beard, Mr. Phillips, so if you could come forward. Thank you. So welcome.
Because I'm not very familiar with this sort of thing, Phillips is giving me a hand here.
Yes.
But basically, I'm really concerned about the fact that this is the only legal access to my property, and an SNA would stop me having access to the whole property, really. So, I have no intention of coming down to the bush anyway, but the fact that it's trying to stop me doing anything would probably devalue my property.
Stephen, Chair, I'm having real difficulty hearing the submitter. It's I suspect Mr. Coffin is too.
So you just eat the microphone, I think, is the way to go.
That was the problem.
Yes.
So
start again, I think would be good, yeah.
Okay.
And just take your time, like we're pretty relaxed. We know that a lot of you aren't used to this. We just want to hear your issues and just in the best way possible.
Okay. So the main issue is that is the only access to the property is through that area, and if there's an S&A put on there and I have to go through there, you know, it's going to make it really difficult, and it will probably devalue the property considerably if there's no access to the main road. You know, we couldn't get stock in and out, we couldn't do anything.
Sure. So I wonder whether you can just, we've put your property up on the screen. Just tell us a little bit about where you are, nearest rivers, nearest roads, just so we can just get the geography right in our minds. Yeah.
Might be better if Neil does that.
Okay.
Okay, yeah. Just put you in the background a little bit of my background. I've been the QE2 Queen Elizabeth Trust rep for 22 years in Taranaki, and one of the commissioners was talking about Taranaki and the work that's happening here. And I've been heavily involved for that time, where we've gone from 80 covenants to 450 covenants, and we've completed 680 kilometres of fencing of those areas in the region. So Taranaki landowners are very proactive. They're not the type of people that are getting into mass land clearance, and they're really concerned about their properties. Kevin's property is SNA 569 at the top of Mount Messenger.
Yes.
And his main access is from the car park at the top of Mount Messenger. I suppose I should say also just a bit of a conflict of interest maybe. I have done SNA work for New Plymouth District Council too, so I just bring that up as a landowner liaison. I don't know if it's a conflict, but I've sort of been involved with District Council and QE2 and landowners.
No, we're very happy to hear your opinions.
So yeah, anyway, the legal acts or the property of Kevin's starts at the top of Mount Messenger in a very small narrow strip heading east, which is all in forest, and then it opens up to his property, to his farm. Presently his access is part of it's a metal track from Mount Messenger, which is part of his, and also across Ngāti Tama land. So he doesn't own doesn't have his own actual carriageway or access to his property on his own land. The SNA has been put in place on the strip of forest from the car park. It's as though the title was surveyed with this narrow strip, which then opens up to his farm, which you can see there, the green strip, and then it opens up to the east to his property. So that strip effectively was surveyed to give access to the property, even though it's not getting used at the moment.
So that's the legal access, that's not the physical access?
It's not the physical access, it's the only, you could say, legal access from State Highway 3, is it? Across from top of Mount Messenger into his property.
Yes.
And the road, or the carriageway, like I say, is part Ngāti Tama and part Kevin.
And we can see on the plan there, when it comes back up, the access track we can see underneath to the north, is that right? Or it wiggles around in a...
So you can see there's a fair bit of it on Ngāti Tama land.
Yes.
And so effectively, for Kevin, he needs, even though it may not be ever be open, but he needs to retain the option to have access into his property from Mount Messenger without having to negotiate, and this is what Kevin is wanting, without having to negotiate with the neighbouring landowners who are Ngāti Tama, to ensure that he retains access to his property. So at the moment, if he wishes to sell, he does not have, or if the SNA is in place and he's got to go through the consent process to put a track in, he doesn't have actual access to his farm. So if that's where it's making the property worthless if he ever wanted to sell.
Yes.
So the parcel shape shows where the survey line, from the road into his property, for that option. there has been discussions going on with council and Kevin, and in the report states that Kevin should be continuing to negotiate with Ngāti Tama to ensure that he can get access. It's not that all that area would be cleared for access, it's just a carriageway that Kevin requires through the SNA or potential SNA, so it doesn't all have to be removed. It's just to ensure that he's got a carriageway through that area to his farm, you know, for that option at any time. I personally, with my sort of work with landowners, we've always had a give and take type situation over the years for the protection, and that's why we've been super successful in Taranaki with the protection of forest and wetlands. Taranaki is the most successful region in New Zealand for landowner protection and landowner involvement. Effectively, we've been doing 25% of all the work in Taranaki for the QE2 Trust. That's nationwide. So it's not that we're out to destroy bush, it's to make it a practical access for Kevin and his farm. So what the request from Kevin is to have the an area removed from the SNA so that it gives him his carriageway into the property. The negotiators, Kevin is the landowner, and Ngāti Tama, if they're discussing or negotiating potential access, that's totally irrelevant in their minds in relation to the SNA. If they want to negotiate outside that, that's up to them. But if it never happened, if agreement didn't happen and the SNA stays in place, then Kevin's farm is landlocked with the SNA in place, unless he went through the consent process, which could be a very expensive undertaking for Kevin to get reports done, ecologist reports, I presume, which council would require. Would that be correct?
So there is a provision for processing fees in the fees and charges schedule. The council planner fees aren't charged if the effects are very minor, but any ecological assessments may come at a cost. So, and yeah, we have had it verified that those values there are significant. So, in likelihood, an ecological report would be required.
But there, just for clarification, there is a consenting pathway.
It's certainly my intention that the chapter will have a consenting pathway for such matters. Yes.
Yes.
Yep.
Commissioner Nash, I've been invited by Kevin to come along because it's got an implication on Ngāti Tama as well. And do you mind if I?
No, certainly. If you've been invited by Mr. Beard, certainly you're most welcome.
Thank you. Firstly, I note the question asked of Ms. Wakaide earlier on regarding the SNAs, and if there's a cultural component, and because the SNA, we're in a set of negotiations with NZTA and with Mr. Beard at the moment, but an SNA is a totally Pākehā concept. It's a layer of interest that is being placed over land that we may inherit at some stage, and that I find offensive. We got a couple of thousand hectares of land transferred to us in our settlement, our treaty settlement. It came with two provisions. One was a covenant placed over the land to take care of the environmental stuff. And the second instrument was a protocol that provided for Ngāti Tama to exercise its rangatiratanga over the area. An SNA just does not fit we've not been consulted on whether or not there should be an SNA in the area, and it's just an imposition that we could do without. There's this notion that the moment land is transferred back to iwi, all of a sudden the public of New Zealand want to walk all over it. It's a sort of walk at will nonsense that only Māori have to put up with, and I think SNA is just another opportunity for another interested group, whether it be forest and bird or any other what they call themselves, NGOs or quasi organisations, wanting to impose their right over land that Māori might own or do own. And take a look here. And I've just been scribbling notes while I've been listening to the Aotearoa presentation, but any imposition at all on tangata whenua exercising their, whatever their custom might be, it's their business, and the moment we have a view on it, I believe that they ought to be provided with the power of veto, because it's their interest. They don't have to explain to the council or to the commission or anyone else what the nature and extent of those interests might be. We're not locked into this 1840 time warp where we can't develop, we can't expand, we can't do what we want to do just because it suits. Or it's not. It's an interpretation that is put on our rights established or recognised and guaranteed in the treaty. God, that's probably all I wanted to say. Thank you.
Can I, perhaps for Ngāti Tama, is Ngāti Tama a submitter in its own right to the proposed district plan? Is Ngāti Tama a submitter? I think you are.
Yes, we did, but we didn't touch on the CCNAs.
No. Yes. And I think we've heard that in general terms, the tangata whenua submitters are supportive of the council's SNA approach. So that's the evidence we have. They want some changes, but that's the evidence as I read it.
Yeah. Ngāti Tama's not imposing or telling other iwi what to do. Yes. What we're saying is the land where this SNA is been identified sits adjacent to the land that we own, and we're in negotiations, as I say, with the beds, and we just don't want any imposition or impediment.
Okay. Could you advise the likely timeframes and the outcomes of the negotiations? Is there anything you could update the panel on?
I prefer not to.
Okay. Thank you.
Yeah.
Okay, just moving back for Kevin and his request. Effectively, Mr. Beard is requesting that the SNA be changed solely so that he can get access into his property, or part of the SNA to be removed so that he can get access into his property if he needs to, if the negotiations between Ngāti Tama and Mr. Beard don't come to any fruition, which is what the council is hoping would happen, but there's no guarantee that that would happen. And going back to the SNA up there, there has been an old track put through that SNA in the past. So on the south side of that larger, wider area of bush, there's an existing carriageway which is now regenerated. So access used to be through that area at some stage prior to Mr. Beard's ownership. So it's not that there hasn't been a track through there at all. There has been a track through there, and it was left to regenerate, like I say. So it's now back in bush. If it was kept open like it would have been at one stage, there was probably no issue about having that access track in through there now at the stage.
So how long ago would that have been serviceable, do you know?
I think the council put the existing road that we're using, council put that in about 1930. They surveyed it in, they did the whole thing, and it was going to be added to the farm. But at the end of it, they didn't actually ratify and submit the survey to wherever it had to go. So it has been surveyed. I have got a survey for it all at home. But so it would have been when that new track was put in was when the old one would have stopped being used.
All right. Is there anything else you'd like to tell us before we go to some questions?
I think Neil's covered it.
No, I think we've pretty much covered. It's not that it's a requirement for totally destroying the SNA and removing it. It's just to give the option to have access to the property if it's desired or required, I should say, down the track. That's what the request is from Beard.
So yes. So before we go to questions, can we just zoom out a bit? Please, Julie. Not on this map, we can't. No, okay. Do you have any other SNAs on your property, Mr. Beard?
Yes, there's one over the back.
Yes. How big an area is that?
Not very big.
Not very big. All right. Okay, so Commissioner Hoffman, do you have some questions?
No, not specific. My questions were going to be about whether there'd been an old track there or had there been access previously, and just some of the background, but that's been explained really usefully. Thank you. But I suppose this is an interesting case where all best intentions don't necessarily match up on the ground. We got access to a land, but it's through the SNA, and the actual access is on the neighbouring property. So it has aspects of real significant challenges on the ground. So thanks for bringing it to our attention.
Commissioner Littlejohn.
Yeah, thank you. This is one of the consequences of desktop planning to some extent, where you identify a resource and protect it, and then the circumstances that it creates for landowners based on their titles becomes apparent afterwards. I'm just interested, in your submission, what did you specifically request? What's your, okay. So you only made a further submission, is that right?
Yes.
Okay. All right. Okay, well that it's something we'll have a look at. I am conscious that I was involved in the Thames Coromandel District Plan, and one of the exclusions from the cannot clear Indigenous vegetation rule is where it's necessary to create access to a building platform where no other practicable access exists. And so that was a scenario that affected a lot of landowners in Thames Coromandel, given the terrain. We don't have something like that so refined here, but your case certainly reminds me of that provision. And I guess all we can say is we'll look carefully at the submissions and see if there's a way we can address it. The other question, just the question I had, how much physical land movement and disturbance work would be required to create a separate, to create an access on that part of your land that you'd actually be able to use for your farming operations? How much is involved?
Well, there's the existing track was an old sledge track, so it's about, I think, 10 feet wide. Some of that's not that wide now. that wouldn't be adequate for today's, to get vehicles in and out today, but so it would be just upgrading the track that's there. There has been, it's not on the ridge top either. It goes around around the side of it, on the southern side.
And what would the length of it be from the road to where you're out of the SNA?
Total guess, probably 400 metres maybe.
Okay.
Might be a bit longer, the council might know that.
Okay. All right, well, no, that's helpful. So, yeah, thank you, Mr. Baird, and we'll obviously give it some thought.
Thank you.
Commissioner McMahon.
Thank you, sir. I've just had a little bit of difficulty following the map on the screen and where it is that the access track dips into the SNA.
Okay.
But I think I understand, and the answers there just about the length of it being around 400 metres sort of helped me orientate myself. Excuse me a minute. The question I have, though, is to the reporting officer, and I just wanted to get some guidance on what the consenting pathway would be that she's indicated would exist. I'm looking at the annotated policies and rules in her appendix from last week, and Ms. Macbeth, I guess what I'm wanting to understand is whether this would qualify as maintenance and repair of an existing track, or whether it would be deemed to be a new track.
I guess the problem with this situation is that I'm not aware of the scale of the work that would be required, and knowing that environment up there, the fear that there would be quite significant earthworks required for a safe track. But I'll just bring the appendix up.
I mean, that's an interesting example, answer in itself, in the sense that the rule as drafted doesn't put any metrics around the scale of the work in terms of the amount of earthworks, the amount of vegetation clearance. It's simply, if you're necessary for the maintenance and repair of the track, you're a permitted activity under ECO R1. I'm just a little bit intrigued with that answer.
Yeah, it would be, it is a very, quite a unique problem, but this is an example of how many different situations we have to try and make these rules work for. And in terms of existing tracks, yes, there is an argument that it is an existing track. I don't know whether we could rely on the existing use rights under the RMA where it hasn't been used for some time. Perhaps that right may be diminished. So, yeah, it's.
You're talking about the 1930s or before, from what I can.
Yeah.
It's nearly 100 years ago.
And the reason I asked that question is you said categorically that you thought there was an existing or a consenting pathway available to Neil on this one, and I'm just trying to ascertain what that would be. Your answer indicates that it's not clear, and it might depend on the scale of the works when the rule itself doesn't, well, my reading of the rule doesn't include any metrics that involve the scale of works to determine whether you're permitted or not. It's just whether it's necessary or not for the maintenance repair of an existing track, full stop.
Yeah, so
that
there
may go to the problem with the rule itself.
Yes, I accept that comment. So in terms of a consenting pathway, if it wasn't determined that it's an existing track, then it would be a non-complying activity status with looking to policy P3 where it's necessary.
And P3 had the same sort of potential problem.
Yeah, yes.
It talks about a clause for the is necessary for the operation.
Yeah.
And upgrade.
So then we'd be going to clause 3, which is the or as a track. And I note your earlier questions around, is that a driveway? Is that a walking track? Is that a road? So
yeah, it's just that we're having this conversation now at a plan making stage. I can only imagine the difficulties it could be for the resource consenting staff at a consent stage. So, it's important. The meaning of words is critical. So I think it's important that we use this example to get the words right.
yeah, it is a good example. So the answer that I'm landing on now, it would be a non-complying activity, but the pathway is with Eco P3 recognises that tracks, envisages tracks.
Okay. Coming back to a question to Neil. Neil, you've been heavily involved in the covenanting of a lot of significant Indigenous vegetation in the district, and we've heard the success stories, and that Taranaki is one of the fastest growing areas for covenants in the country. We've also heard from Ms. Macbeth that she doesn't want to see duplication in the district plan, and where there's a covenant in place, that's, in her view, an appropriate method to give effect to the policies and objectives in the plan without the need for a formal SNA. And I just wonder whether you've given any advice to Mr. Beard about covenanting and negotiating a covenant over this area of Indigenous vegetation that may allow for the upgrades to the track or any new tracks. Can you advise us on that?
Yes. No, we haven't discussed covenant in that area at this stage. But with covenanting with the QE2 Trust, there is the flexibility of allowing for extra access tracks within a covenanted area.
Yes.
That's a regular occurrence that we do have.
I understood that, and hence my question. I mean, if that could provide a solution, and given Ms. Macbeth's position on not wanting to duplicate provisions, is that something that you might want to discuss further with Mr. Beard?
It's definitely something that could be discussed and looked into on a basis to covenant the remaining area. The section closer to Mount Messenger car park, the road, the state highway, is very narrow, so that's probably only the width of the carriageway anyway. But the balance of that section possibly could be looked at for protection with a special condition in the covenant documents, Schedule 2, allowing for access to the property. And what happens in those special conditions is requirements are put down or specifications are put down for size of carriageways, so that it's not just a blatant clearance as much as they like as part of a condition. It's specified under negotiation with the landowner and QE2 Trust.
Okay. Just seems to me that there's three potential options here. One is to remove the SNA over that part of the land that would need the access way, and that would require some discussion with Ms. Herbert, and I don't know to what extent Ms. Herbert's addressed that, and that may depend on the scale of the works, which need to be defined. That would be the first option. The second option would be to focus on the policy and rules and try and shore up that consenting pathway. And then the third option is the one I just put to you about having covenanting in place with a negotiation about access ways to replace any SNA in the district plan. So no question there, just I'm just clarifying in my mind what the inventory solutions might be.
Yeah, probably I'm sort of speaking on behalf of Mr. Beard, but especially the section closer to the road, probably the preference is to have that SNA actually removed, because there's nothing there to protect once a carriageway is put in. And then it's also a very narrow strip, the next section through to his farmland. So there's not quite sure of the width, but by the time you put the carriageway in, there's possibly not a lot left to protect on each side of that narrow strip. So that, I would say, is the preference for the landowner, speaking on behalf of Kevin, but then looking at the other options as a possibility as well. It's effectively ensuring that he has access without having to go through the consent process. Can be quite long, quite expensive, especially if you've got to get additional reports to support his application.
Yes.
So it would be preferable to try and get something sorted now, earlier, to ensure that he can go ahead and do that if he actually needs to.
Okay, I guess what I'm hearing though is that for that to happen, needs to be some definition about the extent of the works and the extent of the SNA to be removed. So if we were to ask Ms. Macbeth and Ms. Herbert to comment on that, they would need to have some sort of definitive plans in front of them for that to occur.
Commissioner McMahon, Ms. Macbeth is keen for a clarification, but before you do, I'm just thinking about the third option you've posed. We still have a contest in terms of other submissions, not necessarily agreeing that the if an area is not an SNA, sorry, the area is covenanted, it can come out of the plan as a SNA. So that would rely on a decision from us on that higher level matter, wouldn't it?
Yeah, it would rely on a decision on the submission actually also.
Yes, but there are other parties seeking, not agreeing with the council about the premise that if you're covenanted, you don't necessarily need to be an SNA. That's the only question I've got in my mind about option 3.
Yes, I don't want to be seen to be advocating for a particular option. It's just that I heard Ms. Macbeth say last week that in some instances where she'd recommended revision of boundaries, it was on the basis that there was some covenant in place, or in the case of Puketiti, the existence of a biodiversity management plan was sufficient to avoid the SNA.
Okay, well, I just wanted to make that point. So Ms. Macbeth?
I was just going to offer the opportunity to ask Dr. Herbert about that the site visit.
Yes.
So,
Dr. Herbert, you with us there? You can turn your video on.
Can you see and hear me okay?
Yes, we can, thank you.
Ah, lovely. Yes, so I've been staring at my evidence with regard to Mr. Beard's property, as well as the designation online. And I certainly agree it's a very interesting case study, and I do acknowledge the breakthrough difficulty that having the SNA puts on Mr. Beard and accessing his property. I can see in my assessment that the only criterion that I had considered triggered for ecological significance was that the Indigenous forest within this site is part of a corridor of a much larger tract of forest that extended all the way from inland areas to the coast, which is, those types of forested areas that actually connect coastal environments within more inland environments are quite rare within New Zealand. However, with respect to putting a driveway in, I don't actually think putting a driveway in there would necessarily compromise that reason why it's been included as SNA. Does that make sense?
If that's your evidence, what I suggest you do is think a bit more about it, Ms. Herbert, and come back at us in the right reply. You've heard, and that's the beauty of these processes, and why it's great that Mr. Beard, you've turned up with Mr. Phillips just to talk about these things. We do get an opportunity to have dialogue about these matters and bring some more information forward. So if you can consider that and come back to us, that would be very helpful. Thank you.
Sure, happy to do that.
Commissioner McMahon, did you have any other questions?
No, happy to have facilitated that. Thank you.
Yeah, brilliant. Thank you. Mr. Beard, I think you've heard the position we're in. You are quite a unique situation, but for us, we're looking at provisions that apply to the whole district. And these case studies do bring sharply into focus the issues that these sorts of rules need to anticipate when the plan does land on the policies and the rules. So it's very, very helpful. Thank you very much for coming in. I must admit that I think I've been on your property, part of hearing the Mount Messenger original applications, and I think a helicopter landed on your one of your flat pieces of land, and your house was just above the top. And so I'm very familiar with that. But I will say for the staff, some of these examples, it might be worthwhile us as a panel looking at some of the particular examples that we're hearing about on the ground. We have had an oversight and overfly, but we might think about that and come back to the hearings administrators about that. And this is a very good example. So thank you very much. Mr. Phillips, before you go, I just wanted to ask you a couple of broader questions in your role as the QE2 coordinator. Do you still hold that role for Taranaki?
I've just resigned.
All right.
I've been in it for 22 years and I resigned 2 weeks ago, finished 2 weeks ago.
Okay. Well, it sounds like you've done a mountain of work, so well done on that. I think I was a commissioner that noted that Taranaki does stand apart from other regions in terms of the 20 or more years of effort landowners have put into protecting not only SNAs but riparian margins and the regional council subsidies. And it is quite a feature of the region. So with that context, we've heard evidence from the ecologists working for MPDC, Ms. Herbert and her colleague, about the fact that in terms of the mapped SNAs, they think it covers a vast majority of significant natural vegetation and areas of habitat for fauna. There's not much left over that hasn't been mapped. Is that your knowledge as well, or would you say something different?
There has been sites that have been missed, which we've actually picked up through the QE2 process and have protected them since these sites were recognised.
Yes.
Some quite significant sites actually. And there has been 1 or 2 sites that I've refused to protect because of not significance in our eyes, where they've got major issues with weeds or exotics and not a lot of indigenous vegetation. So there has been some missed and some have been put in that shouldn't have been.
Okay.
With how I feel.
So with your vast, so the swings and roundabouts a bit there, with your vast knowledge on a scale, if you want to put a percentage of it, are there 20% of areas missed? Are there 10%, 5%? Just a gut feel.
Way down. 5 maybe, if even that.
5 or less.
Yeah, it's been very, very effective program picking up all.
Yes.
There's not many.
I think Mr. Shaw used the term thorough, or there's been a thorough process of both identifying and protecting through SNAs, all through covenants, all through other legislation, and including certainly people like Ngāti Tama who are really into the protection side of things. So his view is in a thorough assessment. There's not much left over. the evidence in this regard is very helpful.
It's very successful in Taranaki solely, well, not solely, because all the agencies in Taranaki are involved. Regional Council, District Council, Kirito, plus other fish and game, we all work together really well. So that's why the region is thriving. It's now gone to 3 reps full-time on the ground, 2 reps on 1. So it's the agencies make all the difference.
Because there's quite a lot of work involved, isn't there? It's not just a question of legally governing for the Kiwi2 Trust. There's quite a lot of follow-up and working with
the monitoring is, we've got to monitor every site every 2 years.
Yes.
So now with about 480 covenants, we've got to get, it's about 240 visits a year to monitor.
Yes.
It's very intense monitoring.
Yes.
Big job.
So the local forest and bird branches, are they intimately involved in this work as well?
No, not at all. The monitoring is really done by the Kiwi2 Trust.
Yes, but I think I was more thinking about the overall Taranaki view on how we're dealing with this.
We have very little, or the Trust has had very little to do with the forest and bird and mechanism.
Okay, thank you very much. Thank you for your assistance. It is 1 o'clock nearly, I think, and these processes are quite intense, particularly for those hanging on the end of the Zoom. So we will have a break. So I think we've finished our questioning with you, and thank you very much for coming. For the wider team, we will have a break. We'll come back at 2 o'clock just to give people a decent break. Thank you very much.
Any comment?